but you're not that clear.
I'm not that clear.
But I'm still seeing you.
Okay.
Let me
That's
walk away.
happening. Okay. I need to make sure that I've got the right people in
Yes.
focus.
And I wonder if you can zoom in, but those are the right people that you want to focus. This panel here, but also you want to get this, so maybe move it back, like when Jenny does the key address. Yeah, the podium and the panel.
Okay. So walk away.
And I'm going to see if I hear talk.
Yes.
Me like one does start talking.
Good morning, Raquel. I'm a little all over the place.
You made it work?
I made it work, yeah.
Amazing how.
I'm usually quite good with technology.
No, that's amazing. I would have messed it up.
Hi, Becky.
Like broken nose.
Please tell me if you hear me or if I should.
Oh, God. People don't know what I just said.
That's okay. Makita, I'm hoping that you can hear me and that it's not overly loud. Increase the volume, you're saying. I'm increasing the volume.
part of the celebration that's going to last an entire year, and we'll be celebrating over and over again. Because for some of us, I think we have to pinch ourselves to see if this is really, if we're really awake and this is really happening. And of course, I'm talking about the right to counsel for tenants facing eviction in housing court, which is a huge plan. And I know if I started crying about this, I wouldn't be the first person. And I am the first person on this diet. Some of us, like Larry Wood and I at Housing Court Answers, and many of the people in this room have been working on this issue for many, many years. I think none longer than Andy Scherer, who's going to be presenting our Housing Justice Award today. I was calling before, I was saying, is it all right to call Andy a very young criminal smooth? He is the sort of, I want to say, founding father, is that rude? Of the right to counsel movement in New York City. He's been a guiding light for the Right to Counsel Coalition in terms of keep reminding us why it needs to be a right, and what is a right, and what does that mean, and how do we make that happen, and how does that work legislatively, and how does that work within the law and within the courts. And while active tenant leaders in the city with CASA and Los Suris and other organizations, Catholic Migration, Goddard, if I'm not seeing you and missing you, shout out your group, made this happen, made the ground game happen, and made it come to fruition. I think that Andy was a guiding light in terms of always reminding us and hosting our meetings and reminding us what the right to counsel was. He's been very involved with Housing Court Answers since its founding, and as I said, he's been involved. We were advocating for right to counsel, and probably one of the reasons why we were founded, back when Andy worked at Cross Legal Services. He worked with us on filing the Donaldson case, which was our first failure trying to get right to counsel through the courts. The court said, no, the legislature has to create a right to counsel. Housing Court Answers worked on the right to seniors counsel, right to counsel for seniors in 2009 that he was involved with, and here we are in 2017 where we won, and no Andy has an incredibly valuable network of legal voices that he brought into this coalition, including former Chief Judge Jonathan Littman, bar leaders, national and international voices on the right to counsel. And these voices in turn help change public opinion and started people thinking, you know, the New York Times op-ed pieces, in places like that, sort of that sort of elite level of people thinking that it was wrong to be evicted in housing court unless you had an attorney representing you, and maybe it was wrong to be evicted, period. So that's a further discussion of this, right? Andy is currently the policy director of the Impact Center for Public Interest Law at New York Law School. He worked for many years for Legal Services NYC, serving as its director for close to 10 years. He is the principal author of the Tenant Practitioner's Bible, Residential Landlord-Tenant Law in New York, known with great affection in our world as Sharer. And as I said, it's the book that we all turn to when we want to know, like, can you do that in housing court? Is that part of the law? So it's a great resource to all of us. And Andy is going to present our housing justice award.
Thank you, Jenny. That was really nice. So I could not be more thrilled to be asked to do this today. We're in a remarkable moment. You know, as Jenny said, a number of us in this room have worked on this for decades, and we are on the verge of getting there. We're not quite there, but we're on the verge of getting there. We're making history. We're really making history. And with Mark and Vanessa's leadership in the City Council, with CASA's leadership at the community level, its organizing, its formation of the New York City Right to Counsel Coalition, that's the reason why we are where we are. Make no mistake, the mayor's announcement on February 12th that he's finally supporting it for 214A, and it wasn't easy to get him there. And funding the so-called universal access to counsel, this is an unprecedented breakthrough in the right to meaningful access to justice for low-income New Yorkers facing eviction. It's unprecedented in the United States. We are the first jurisdiction to do this. The world of tenants' rights will never be the same. Housing court will never be the same. The campaign in New York City for the right to counsel, it was remarkably successful. It was brilliant. With CASA in the lead, we built an ever-broadening coalition and garnered widespread public support for the right to counsel. We got support from labor, from community groups, from bar associations, from faith leaders, and we got press attention, all kinds of editorial support. The lead sponsors of the legislation, Mark and Vanessa, worked fearlessly, strategically, and tenaciously to build support for their legislation and shepherd it to fruition. They got 43 of the 51 council members to sign on as co-supporters. They worked relentlessly to convince the speaker and the mayor to come on board. They took strategic advantage of the twists and turns of the political world, the housing dynamics, the economics of New York City at every turn. And there was a remarkable synergy between the coalition and legislators. I felt like there was almost a telepathic communication. You know, we figured out what needed to be done, and we made it happen. And the work has really, really paid off, like nothing in my very long career at this point. We have a guarantee that in 5 years' time, every low-income New Yorker can have counsel when facing eviction. Already underway. I mean, on our way to getting the legislation passed, the city is already appropriating over $70 million a year. There are over 200 new attorneys doing this work. I don't know exactly how many they're working for, but it's got to be at least double, if not triple, the number of attorneys that were in housing court. The city reports that 27% of tenants are now being represented in housing court, as opposed to just probably less. This is just 1%, but even if it was 5% or 10%. It's way, way more intense. Evictions are down. The housing court judges are reporting a different atmosphere in the court, a different set of expectations about what happens when a tenant comes into the court. And the culture's changing. I call it the ecology of housing justice. We've disrupted that ecology, and that ecology is going to change. And it's got to change for the better. It's got to change for the better with this kind of level of representation. This is a tremendous victory. It's a victory because low-income people will now have a fighting chance to stay in their homes and in their communities. And they know that someone will have their backs as they face the accelerating onslaught of gentrification and displacement. This is a tremendous victory because it sends a message that the lives and communities of low-income people and people of color in this city matter. At least here in this city. This is a tremendous victory because the right to counsel is an expansion of civil rights. And rights mean something. Rights shift power and give people the tools to make demands on the people who hold power over them. Rights give people the tools and the courage to organize for change. And the rights of low-income and marginalized people particularly mean something in this crazy, crazy moment in history where we have a narcissistic billionaire madman in the White House and all fundamental human rights and liberties are at stake and under attack. New York City is leading the way, and other jurisdictions will follow. We already know that Philadelphia, Washington, D.C., Chicago, San Francisco all have movements now for a right to counsel in housing. But look, well, this is a tremendous victory, and we have to celebrate. We have to relish this moment. Our work is far from over. We have to continue to demand that the city abide by its promise and make this a true, universal, and lasting guarantee for all. We have to continue to demand that the city implement the program in a way that gives priority to the communities and the people in this city who have the greatest, most immediate need. We have to continue to demand that the legal services providers get funded to do this work at a level that enables them to provide the highest quality assistance to their clients. And most importantly, we have to continue to work together towards a true right to counsel that gives low-income people the legal help they need in housing court, but beyond, to support their efforts to preserve their homes and their communities. Counsel that works shoulder to shoulder with clients and community organizations to place demands on owners, on government, on the courts. Counsel that does not accept the rules of the game, but works together with clients and their communities for changing the laws, changing the policies, changing the court system that favors the rich and the powerful. The right to counsel is not an end. It's a beginning, and it's an exciting beginning because it creates enormous opportunities for further change. So, for all these reasons, I'm thrilled to be presenting the Housing Court Answers Housing Justice Award to these wonderful folks. The legislative leaders and the community organization played a central role in making this happen. And I think, well, maybe I'll pull you up here. I was going to do it all at once. I'll do it one at a time. I'm going to start with Vanessa Gibson. Vanessa is a council member and former assembly member from the South Bronx with politics in her blood. Vanessa could not have higher energy, could not be more devoted to her community, could not be more committed to the right to counsel. She's got a strong, powerful voice, both in its resonance and in its moral weight. When Vanessa speaks, people listen. And she's got great political instincts, and she's a real, true leader. So,
I think it's because I have a loud voice. Good morning, everyone. Good morning. It's great to be here. I am so excited and thankful, and most of all, I'm humbled. I stand before you as a public servant in my 4 years in the New York City Council, formerly as a member of the New York State Assembly, and I'm so grateful. I'm grateful that every day God wakes me up with a plan and a purpose. And throughout all of the work that we've done in the New York City Council, working with all of my colleagues and all of our tenant leaders and advocates, nothing means more to me than this great accomplishment. And so I am here to celebrate with all of you. I am here to say thank you for never giving up. Thank you for fulfilling the plan and purpose that we all have to make sure that throughout it all, we fight on behalf of tenants and all New Yorkers. I am grateful to be here once again at the annual Conference of Housing Court Answers, and I want to thank our phenomenal leader, Jenny, Murray, and the staff. Thank you. I've known Jenny for 7 years now, and I used to do all of this work at the state level on MCIs and rent regulation, and though I don't miss those days in Albany, but I truly appreciate the work that Housing Court Answers does each and every day. And I want to thank Andy Scherer for your leadership, your commitment, for your dedication. Every time we have met, I feel your passion. And I just said to my colleague, I didn't realize Andy has like a real job too. Because you have been not just the trailblazer and the pioneer behind Right to Counsel, but you have really given us a lot of strength. And so I thank you for being a source of encouragement, a source of strength, and a source of motivation for each and every one of us. Thank you from the bottom of my heart. And where would we be without my colleague in the New York City Council who really led this effort, Councilmember Mark Levine, my friend, my colleague, for everything that you have done on behalf of the entire coalition, on behalf of the entire city. I thank you. It has been an absolute pleasure working side by side with Mark at every tenant rally, every press conference, every march, every meeting that we have had to simply get to this day. It has been a pleasure, and I truly appreciate working with you. Thank you, Mark. And I would not be the legislator I am, I would not be the champion for the 16th Council District, certainly on behalf of the Bronx, if not for CASA. I met CASA over 10 years ago when I first started working for former Assemblymember Aurelia Green. And I never knew that 10 years later, God would elevate to CASA such an incredible opportunity to continue to be a strong voice for so many tenants across the city. And I meet with CASA regularly. We were just together in the pouring rain on Saturday, fighting for tenants for quality and affordable housing in the Bronx. And CASA has been an instrumental part of this conversation. And from the bottom of my heart, CASA, Susana, Carmen, and Lourdes, and Fitzroy, and everyone that's at the CASA family, I say thank you. Thank you, thank you, thank you. I could go on and on about what this award means to me and what this accomplishment of Right to Counsel means for all of us, but I will just simply say just a few things. It means fairness, it means access and opportunity, it means leveling the playing field for so many tenants and families that deserve it. We always say affordable housing is a right and is not a privilege. It is a part of the basic fundamental principles that we have as New Yorkers to protect those vulnerable tenants and families that really rely upon all of us. And as we are continuing to have these conversations, we're not just talking about it as an administration, but we're committing money where our commitment is, and I am grateful for that. So I stand before you as a proud advocate, as a proud council member, but most of all as a proud resident myself, knowing the impact of what we are doing, knowing the faces and the families of those who will benefit from this great work. The faces of homelessness are real. They come from our communities, they're our neighbors, our family members and brothers and sisters, and we must always do everything that we can to not only stabilize their housing, but preserve their housing. And as someone who's been doing this for just quite a while, not that long, I've seen the faces, I've seen the success stories, but I also see the challenges that we continue to face. And so I only accept this Housing Justice Award on behalf of all of my constituents in District 16. In Claremont, Claremont Village, Concourse Village, Highbridge, Mount Eden, and Morris Heights, the 160,000 residents that I am proud to represent in the New York City Council. I accept this award on their behalf for all of the work that we have done collectively, all of the work we will continue to do. Thank you so much, and I also want to thank our speaker, Melissa Mark-Viverito, and all of our colleagues in the New York City Council. I want to recognize and thank our mayor and this administration for finally recognizing that universal access and right to counsel is something that not only will make us, and not only will allow us to make history, but really will allow us to make our footprint in history to say that access to counsel should always be a right and not a privilege for those who can simply afford it. So on behalf of our district, thank you so much. Congratulations to each and every one of you, and I look forward to the bill signing and continuous work ahead. God bless you all.
Thank you, Vanessa. That was great. So, next award is for Councilmember Mark Delaney. Mark is a councilmember from Upper Manhattan, a former educator, and a persistent champion of justice and a relentless crusader for the rights of counsel. He's been accessible, friendly, likable, but beneath that very likable, friendly, smiley facade is a very aggressive advocate for the things that really count. He's a creative, strategic thinker, and like Vanessa, a legislator with great political instincts and a true leader. And just one more thing about both of them. These guys are young. From where I stand, they're very young. And watch them, because they both are really going to go places. For you, the Housing Justice Award from the Housing Court Answer. Thank you so much.
You know, only in politics can a guy who's 48 still be called young. Standards. And by the way, putting Vanessa and I in the same age category is very generous to me. I got more than a decade on her. This award means so much to me, coming from all of you, coming from you, Andy, who really gave birth to this movement 30 years ago, and we've done so much to nurture it over the last 3 decades. And I really want to pay tribute to all of you this morning, the activists, the legal service providers, the judges, the nonprofit leaders, the thought leaders. You all own, every one of you owns a piece of this victory. So give yourselves a big round of applause, please. And we'll be sharing the stage here today with my amazing colleague, Vanessa Gibson, who has been the best partner in this journey that I could ever possibly have dreamed of. Thank you so much for your friendship and your leadership, Vanessa. Thank you. And what's up, Casa? Where are the orange shirts? But to witness your organizing prowess over the last 3 years has just been awe-inspiring. You know, the people in this room really, in so many ways, what you've done over the last, not just 3 years, but 30 years has made this possible. Housing Court Answers, in there in the trenches, during years of incredible scarcity of resources. You have saved the homes of more New Yorkers than we can possibly count. You have brought a measure of justice in housing court in a time when most people were ignoring that arena. It's just amazing to look back and what you have achieved and what you continue to achieve. All of you have proven the models that work and bringing justice to housing court, models that we're now building on now. Many of you have built the intellectual case, the academic case, the financial case to show what was possible that made this policy victory possible. It really is incredible. And I have to admit that when we introduced this bill over 3 years ago, I would have put the odds of our success at somewhere around 1 in a million. I really saw this as an incredible long shot. But I hadn't met any of you yet. And or many of you I did not know at that time. And as I came to see your commitment and your organizing skill and the community resources you brought to the table, I almost immediately saw the possibility here. And we started scoring wins right out of the gate. As Andy says, we have brought about more than a 10-fold increase in the money the city's putting towards anti-eviction legal services. We established an office of the civil justice coordinator. Now, in this administration, first time we've ever had that for the city. So we were proving to ourselves and the world that we could do this. And this is just going to have an incredible, incredible impact. It's going to change New York City. It's going to have a human benefit for the families who stay in their homes. It's going to reduce the homeless crisis, since we know that the largest source of family homelessness remains eviction. It's going to protect thousands of units of affordable housing that might otherwise have gone vacant and flipped to market rate. The impact of this is going to be felt for many, many, many years. And while we have a lot to celebrate now, we do still have a lot of work ahead of us. We have to land the 747 of passing the bill, which we hope and expect will be done in the next month or so. We need a strong bill that will enshrine many of the principles that we fought for in law. And then we've got an implementation over the next 5 years. And there will be many, many, many things for us to argue and fight about. We need to make sure it's implemented in a smart way, in a fair way, in a way that will deliver for tenants, that will work for the legal services community. So we can't just go home now. And I hope that in the Trump era, that this teaches us that we can actually still score wins now, that it's not only about playing defense, we have to do that to protect our people, but we can still be on offense and score wins for economic justice and social justice. This proves that it's possible. It's already inspiring cities around the country. And let this be only the first win that we score. Let's figure out absolutely what we can do as activists and social activists. How about we tackle vacancy decontrol? That would be a big one. Let that be the next focus. Let this be more. Let this be the beginning of our activism in making New York City a fairer and more just place for everybody. Thank you for this award. Thank you, Vanessa. Thank you, Andy. Thanks to all of you for your incredible work towards this family. Thank you.
Thank you, Mark. So the last of the awards goes to Counsel. And I have to say, Counsel just blows me away. Counsel is an amazing, remarkable, successful, and powerful grassroots community organization. It's led by tenant activists. It's played a critical role, a leadership role in creating a coalition and building the Right to Counsel campaign. CASA's tenant-run study of the Bronx Housing Court done a few years ago called Tipping the Scales really resurrected a dormant Right to Counsel movement. CASA has been the backbone of that movement. They brought together really one of the most successful housing rights campaigns New York City has ever seen. They reached out to other organizations throughout the city and brought them in. They used social media effectively. They put together videos, tweets, phenomenal website. They led the coalition in turning out hundreds of tenants whenever the moment was important to get people out. They gathered thousands of signatures on petitions. They collected, I don't know how many keys to demonstrate the point about people losing their homes. And while CASA is truly tenant-led, and the CASA leaders are a consistent and constantly growing voice for for the rights of people in the South Bronx, the Bronx as a whole, and the city of New York. I do want to single out Constance director. Because Susanna Blakely really does deserve special recognition. Those of you who participated in the coalition actively know that Susanna's leadership or coordination is really something to behold. And anyone who's been there knows what I mean. And she just has this remarkable talent for motivating people, getting them to participate and take action, and an uncanny instinct for developing strategy and moving things forward. But she's part of a group that is just an amazing set of leaders. And today, to accept this award on behalf of Counsel, we have Randy Dillard and Carmen Vega, who have become friends of mine through this effort, a couple of remarkable tenant leaders. And I'm going to call them up here. And I think
I know I'm not in a fashion show, but you asked for it.
at the house, guys.
It's an honor to be here today. When this journey started out, they say sorrow comes at night, joy comes at morning. This is a joyful moment for me, personally. Half of y'all don't know me, but my story is a few years ago I almost died. When I got out of the hospital, I was served eviction notice. That's why this is important to me, and that's why I've been with Counsel and the coalition. Because no one should go into housing without an attorney. No one should face that, no family. No one should wake up in the morning and not knowing where they're going to live or lay their head. No one should have to think that they got to go to a shelter to live, especially for a non-paying who didn't hold the hand. I found Counsel to learn what my rights was, and within my community was an organization called POTS, Part of the Solution, where I found the law. In 2.5 years, I was deported. But today, I'm in a brand new apartment because I had an attorney. Today, my daughter is in college and not in the shelter, being shamed because her father let her down for some reason that she couldn't understand. Jenny, when I met you, I thought everybody was just doing things for the money. No. Not that y'all getting paid a lot. But I thought it was just a job to y'all. But over the years, with the coalition and y'all, your heart is into your work and not into your check. That's what I mean. When I met Mark, it was on 250 Broadway when we first started the coalition. Vanessa came in, we sat early, Vanessa came in, I sat beside you and you asked me, who is Counsel? And I tried to explain it the best that I could. I want to thank you and Vanessa for the long, hard work that we have done together to make this happen. Angie, I don't know what to say about you. You touched me when I realized that you've been fighting this cause for 30 years. now I can see that this is happening. Somebody like me never thought that I would be in the president. Never thought that I would be a part of something so great. And I want to thank you for working with me, helping me. Thank you. I'm ready to finish, but I gotta say something about my director.
No, you don't.
Yes, you do. Yes, you do.
Susanna. She works hard. The insight that she has in seeing problems and yet solving problems, I don't know how she comes up with it, but she does. I don't know what made her take interest in me, because she got me talking to reporters. I've been on TV 2 or 3 times. This is something I don't do. She works hard. Not only is Susanna my friend, and I guess we would say colleagues, but Counsel is a family. The whole organization, and that's why Counsel is so powerful, because we all love each other and we believe in the work that we do. The community suffers when it has no understanding or education. And to be able to educate people of the right, like me, and everybody else in the book that Andy was talking about, tipping the scales, going in there and doing surveys, suffering. Over these 5 years I've been with Counsel, I've seen a lot of families crying, telling me their problems. But as I said in the beginning, sorrow comes at night, but joy comes in the morning. And that joy is the right counsel.
Good morning, everyone. I'm not going to tell you my personal story since I'm on the panel, but what strikes me with the right to counsel is that in 2008, as my health was deteriorating, I had to stop working, and I almost floored the entrance of shelters because I was being attacked by my landlord. And as my health continued to deteriorate, I found myself fighting a battle that I'll tell you more about in my presentation that left me questioning who's out there, what's out there, and who's going to have my back. And when I looked over my shoulder, there was no one that had my back. I was taken to housing court by an unscrupulous landlord on the worst landlord list, not knowing what the next day was going to bring. My anxiety got to a point that fear took over with regards to where am I going to live. So today is very emotional for me, knowing that there are people like Casa, Susanna, Shayla, the rest of the staff, Andy. I happen to know Mark from my other work in nonprofit in the after-school field. So I'm blessed that he transferred because he had no idea that I would be fighting this battle to have a roof over my head. And Vanessa, who's my city council. But it's also the love that I have, not only for organizations and allies like Housing Court Works, Urban Justice, who has been defending me, and legal services in our foreclosure, but it's also the spirituality and the health that I look for with my neighbors and my friends and the people that I love, such as Randy and others. So this fight that we had and that we still continue to have, and as Andy says, this is not the end of the fight, this is just the beginning, it's real. I want you to remember my face and Randy's face. Picture it, take photos. Because the discrimination that we've had to confront, the racism that we've had to confront, comes in all shapes, sizes, colors, ethnicity, social economic background. It doesn't matter if you're on public assistance or subsidy or you have a double master's. That doesn't play any part in housing court when you're taken to court for frivolous court proceedings. So today's celebration is the right to counsel, but there are millions of us facing this battle. And it's only with all our strength and all our power that we can rise and overcome all the racist tactics that are used against us. So let's celebrate RTC, but let's remember that at the close of today, the battle continues. Thank you.
Well, congratulations and our eternal thanks to all of you. There's really nothing more to say. Our next panel.
Yeah, sure. Thank you, Mark and panel, and let's have another round of applause. I'm still struggling with the ears. Very moving. Our next presenter is Adrienne Holder, who is not in the room. Here she is. Adrienne. Adrienne is a longtime board member of Housing Court Answers. I think are you our treasurer or our secretary? Our secretary. Yeah. It's all Judy Builder's fault that I'm a part of it. Right. Since 1997. So Adrienne runs the civil division of the Legal Aid Society, and she is a familiar face to many of us in the housing justice movement. And she's going to present basically our thanks to retiring Justice Fisher. And so I will turn it over to you now.
So Judge Fisher is getting a lot of love right now, I know. No, it's okay. It's all good, because I have a lot to say about you and continue to talk to folks. So again, I'm Adrienne Holder. I'm the attorney in charge of the civil practice of the Legal Aid Society. These are some very interesting times that we're living in for all kinds of reasons. But I have to say it's also a very exciting time to be an activist, to be a lawyer, to be a part of this community that we have here. We hear everyone talks all the time about what a close community we are, that we all are kind of in this fight together, and it really is true that we are together, that we support one another, and no matter what our backgrounds or what our positions are in these various struggles around housing, we understand that this is about civil rights, it's about empowerment of our communities, about making sure that our communities actually are seen and are heard, and that we can stabilize those communities. And our comrades in this fight, they take the form of a lot of different professions. And so we have Fern Fisher, who's always been an advocate in these areas. Fern graduated from Harvard Law School, I think in 78. And she joined the legal services community as a housing attorney at Harlem Legal Services. During her time as a practitioner, she became the deputy director of Harlem Legal Services. She also was an attorney with the New York State Attorney General's office. And Fern always was looking at different ways in which to represent people, to empower her clients in the community. And she always had an understanding in all of her various roles that she needed to serve and she needed to find more innovative ways of doing it. And so she became a housing court judge in 1989, I believe, and at which time she took a really hard and critical look at the way housing court was run. I believe in 1990 she was elevated to civil court, and then in 1996 she became the administrative judge of the civil court. And right away, Judge Fisher was always looking for innovations, and she changed the way in which housing court ran. She introduced a number of programs, and it was hard. And it was something that, we always know that the Office of Court Administration says that they don't have enough resources. We always know that the judges are always feeling overwhelmed. But Fern always pushed and pushed and pushed. And then in 2009, of course, she became what she has now. She's retiring from her positions as Deputy Chief Administrative Judge as well as Director of the New York State Courts Access to Justice Program. A job so big that her replacements had to be two people, Oh, 3 people, see? So big. Four. Someone who had 5. It's a really big job. But, you know, Judge Fisher was the first to actually look at how housing court was structured. She has always said, and she's been on the record many times in saying housing court is one of the most important, most exciting, but very, very essential courts in the state court system. Judge Fisher was the first to not only look at how to deploy pro se attorneys, or now I guess they're attorneys in the help center, in more innovative ways. She looked at unbundled legal services in ways that sometimes prove controversial, but always were innovative and always with the eye of providing greater access to justice. Judge Fisher was the person who decided to look at public and private partnership to actually bring lawyers to work into the courts through a courthouse-based model where she actually targeted zip codes. And it's a program, the Housing Help Program, that grew out of that, using social work services and her push to always make sure that HRA had a role. She always thought that it was essential that they have a role, an expanded role in the courts through that program. And that's the basis of which we constantly are looking at our programs today. And in fact, as we start to roll out universal access over the next 5 years, we know that it's going to be that zip code model and a courthouse-based model with the idea that we have other services that are going to be there that we now stand on. And it all became because of a great vision and a great innovation that Judge Fisher decided to push through on a very personal level. She has served as an inspiration and a mentor to many of us, including me, through the years, always opening up her heart and her home to a lot of us, and her wise counsel on the different struggles that we have faced as activists and as attorneys and providers and community leaders for these services. And again, it's my pleasure to introduce to you our retiring judge, Chief Judge Fern Fisher.
Good morning.
Good morning.
As I address you for the last time, I want you to know that I feel like Moses. We did all the work, you did all the work, and I want to be in the promised land where universal access to justice really kicks in. Congratulations to each and every one of you in this room that made it happen, particularly Andy Sharon, my where is he? Who's also my co-author and partner in crime. And to CASA, I just did a study on legal empowerment for a foundation. And I cited CASA as a prime example of true legal empowerment and what you can do when you give the community the power to make change. And we're not going to make change in this country unless we empower communities to make the change. You know, everybody says to me, well, why are you leaving the bench at an early age? Well, first place, it's not such an early age. Pretty old. I've been on the bench for 28 and a half years. But this election in particular kind of gave me the push to make the final decision, to return to my roots. And although I have enjoyed being a judge and being a neutral, it's time not to be neutral, to return to I started as an activist and I want to finish my life as an activist. So I will be out there somehow with you, hopefully making more change in the world. And I'm probably going to land in an academic institution to give me freedom to do what I want to do. Housing court is not perfect. It's always a work in progress. charge of housing court, it is a different court. It is not the court that I practiced in when I was a professional attorney. But nevertheless, there's still changes to be done. And clearly universal access to counsel will make a difference, but that's not the only thing that needs to be done in housing court. And I'm counting you to keep the fire under the feet of the individuals who will be running housing court. I am leaving the court in the hands of the Honorable, boy, talk about timing, Gene Schneider, who just walked in. And I know that you know that Gene knows the book, and that you will find an open ear and a warm heart to the issues that are facing litigants in housing court. I wouldn't be leaving housing court if I did not know that it wasn't going into very capable hands. And so please, you know, I've always said that housing is one of the most basic and the most crucial of human needs. Without a home, without shelter, people's lives just begin to unravel. It's at the beginning of the process. And so therefore, it is important that each and every one of us continues to do what we can do to keep a roof over people's heads. These are tough times, and I think they're going to be worse. Now, we are a little bit better off in New York City, but remember, there is the rest of the state and the rest of the country. We do not have the luxury of taking a break or a rest. The fight must continue, and I count on you to lead that. Thank you so much for receiving me every year. Keep up the good work. We have like 2 minutes, 3 minutes to take questions. In terms of the future of housing court, you know that there's a new task force that's headed up by Judge Joan Lovis, a former housing court judge, and Judge Peter Thomas, the presiding justice of the first department, who is also a former housing court judge. I do not know how they're going to operate. I have absolutely no clue. I am completely a lame duck at this point. So you should figure out what the process is and so you can have some input. There are no major changes coming up in the next few months. Let Judge Schneider get her feet wet, and things will continue as is until this task force comes back up with a report. I have to tell you that the housing judges and their law firms have done their own review of housing court because it's been 20 years since we changed, we did the initiative, and so they will have some input into the task force, but I'm eagerly waiting their report so I can see what they think the future of housing court should be. Any quick questions or comments? Judge Schneider is in the room, so yes.
Did the possibility ever arise that, or was ever considered that the housing court, the administrative role it has, be carried out in the same manner as small claims court, just removing the jargon and allowing the citizen to represent their interests?
I doubt we will be able to get that through the state legislature, which is very difficult to get anything through. But I think it's a mixed bag when you talk about getting rid of some of the legal procedures. I think that some of the advocates here would say that law can make a difference in keeping people in their homes, and small claims, which is a looser standard, might actually not be strong enough for a housing issue.
You mean the standards of small claims?
Yeah.
Could you break that down? I'm not sure what you mean.
In small claims, the standard of proof is substantial justice.
Standard of proof.
Yes, that's what it is. And so it's not so great when you deal with shelter.
On behalf of Counsel, I want to thank you for always having your doors open for us when we come to see you and making the changes that we have asked you today. And I want to thank you. See you go, but Counsel, thank you.
By way of announcement, and then, you know, I want to turn the program back over to Jenny, because I know you have a very busy day. Finally, after a number of efforts, we had the administrative board approve this week a plain language notice of petition. And to give credit where credit is due, Rochelle Plattman, who is my chief counsel and has been with me for 23 years. A lot of crying in my office, a lot of crying, sometimes it's me. Worked on this with me, she did most of the work. It is in plain language and also gives people some basic information where to get some help. It is now a 2-page notice petition. It will be also translated into Spanish, and then there'll be links to other languages on the website. I mean, it's so remarkably different than what the notice petition currently looks like. I think it'll make a big difference in people's clarity in terms of knowing that they're subject to being evicted. And you know what, as I leave, as one of my last things, I can put my head down on the pillow, and I'm happy to say that finally, it was like getting close to I'm leaving June 29th, I'm like, really? Come on, people, we gotta get this passed. So it's passed. It's just a small measure of access to justice for people in housing court, but you know what? Small steps always make a difference. So, see you. Thank you.
Just before we'll have a panel come up. I don't know how many of the panelists have arrived, but those of you who are on the 11 o'clock or 10:30, whatever panel, you can start coming up. Just briefly, I want to say thank you to Fordham Law School for hosting our conference this year, and for the many public programs that Fordham sponsors. For those of you who are interested in access to justice issues, people might be a law student or a lawyer to come, but I'm neither. And I frequently did their programs here, and they're very accessible, and they're really wonderful introduction to a variety of access to justice issues. They also bring speakers from all over the country on really important debates over social justice. So, Fordham Law School is a great place. Once again, I thank them for hosting us, and to Dean Matthew Diller for hosting us here. I also want to take this time to thank the members of our board of directors, particularly Larry Wood, who is an organizer, and you'll hear from next. Organizer fashion. Thank you so much to Adrian Holder, who you just heard from, who had the fun task of thanking retiring Judge Fisher. And thank you to Michael Williams, who was second from the left, who is our board treasurer, yes, and who has the difficult task, or the complicated task of moderating this panel today. And I do want to, as someone earlier said, is recognize the great work done by the staff of Housing Court Answers, who work, and those of you who've been in Housing Court know Housing Court is a dirty, crowded, difficult place to work every day. And I'm really honored by the staff that we have who go into the Bronx and Brooklyn housing courts and all the other housing courts every day from 9 to 5 and stay there helping litigants who don't have attorneys. I know that we're all very excited about the changes to come with Private Counsel, but for right now, thank them for the tasks that they do and for the incredibly hard work. And of course, they look like they're all just here on their phones texting with their friends, and of course they're not tweeting. And so that everybody, they're recording and tweeting, and so that everybody knows what we're doing today and what the speakers are saying today. So once again, thank you to the staff. I do want to say another thing is that in your packets there's this flyer. I wanted to draw your attention. for next Monday, May 22nd, from 6 to 8. There's going to be a teach-in on right to counsel. It's going to be at the University Settlement on the Lower East Side, and it's super important that as many people get involved in this campaign as possible. So if you have members or you're working with folks who might be interested in this, particularly tenants who are interested in learning about the Right to Counsel campaign and what it means and how they can get involved. This one's in the evening, and so tenants can come and attend and learn about it and get involved in the campaign. As all the previous speakers have mentioned, the battle's not over yet. Legislation hasn't passed the city council yet, and the program hasn't rolled out. And we really need as many activists to be involved going forward in the coming 5 years as the program rolls out. So please urge people to come on May 27th. And I'm going to hand this over to Larry now, who is the chair of our board of directors and a longtime tenant organizer, and very involved in not only the Right to Counsel, but also in advocating and organizing around the Rent Guidelines Board, which I think of as the two signs of a resurgent tenant power and a resurgent tenant movement in the city, are the fact that we've had an incredible campaign on the Rent Guidelines Board, and a very successful one, and no small part to CASA person, whatever, CASA staff member and RDB member, Shayla, who's sitting there many tenants who've been active in this movement, along with Right to Counsel, are the two signs of this incredible increase in tenant power. So, here's Larry Wood.
Let's give a quick big hand to Jim Laurie, director. People kept making reference to 30 years, but it's actually been over 35 years that we've been involved with the struggle. Housing Court Answers formed as the citywide task force in Housing Court. It was at the 10th anniversary of the creation of Housing Court, which was created in the early 70s. The early 80s, we had a conference to critique Housing Court 10 years later. And we realized it was a far cry from what the vision was, a place for code enforcement, a place for justice. It was a long way from that. Andy Shea wrote our initial bylaws. Judge Schneider was on our early board. When we formed, we really were a coalition. And out of that coalition, we grew into a staff-funded organization. I joined the board in the late 80s and became the board president in 93. And it's been an incredible experience for me, individually and organizationally, the growth of the organization and the work we've done. And I was thinking about what to say today, and I'm thinking, think globally, act locally. And when I think about what is going on in the world and in our nation, is deep anguish, is pain, almost a feeling of helplessness. I think I've gained 8 pounds since November. It's been a struggle. But I realize I have to keep active, and keeping active locally is what I have to do. And Jenny's right, we've had some local victories, and that inspires us to keep going and to inspire our nation to get back in resisting and taking back our country. With these moments when the stars align, it's been a progressive mayor, a progressive city council, the hard work of CASA, all of the studies and reports and research that laid the groundwork for this moment to happen. And it's only one step. All the other speakers said it. We have to continue to work. It's not an end. We're going to have to monitor the implementation through other aspects of Housing Court, not just the right to counsel, but that plain language. I'm so glad to hear the judge talk about the plain language being implemented. That was another chief reform we've championed. Another key aspect of our work over the years has been what we call clean hands, and that's meaningful code enforcement. A right to counsel is not going to address HB actions. We're still going to have a lot of work to make sure Housing Court is truly a place where tenants can find justice. And even those small unrepresented landlords, they need a level playing field as well. And we serve pro se litigants, so we also assist small property owners, but the bulk of the work, of course, are the tenants who largely were on the short end of the stick when it came to trying to get justice in housing court. If you'd like to take a look at the packet, in the past at our annual conferences were annual membership meetings. Each of the borough coordinators would give a report. So please, when you get a chance later on, look at the different borough reports, because another important aspect of what we do is monitor and critique housing court and provide feedback around court offices, around procedures, around the physical plant, and there's a lot of work that goes on year round. We also have different reports about the navigator system, about NYCHA, which is our newest work at Housing Court Answers, is assisting those litigants that are brought in by NYCHA as their landlord, and they also need a lot of assistance. So you have these borough reports, the incredible staff. If you look in there and take a look at our incredible staff, they make the board look good because of their great work. And I just want to give a hand to our great staff. I joined the board, our annual budget was about $140,000, and now we have close to $1 million with unionized staff, and I'm just so proud of them. And a really hardworking board. Many of us have been officers for many years. We were all organizers or lawyers in our various organizations, and we've risen up the chain of command in different respects, and we've become our organizations as well. And I do want to thank Fordham for hosting us. We used to have conferences here many years ago in the old school. We bounced around to many locations, and it's nice to be back here in Fordham. One of the things I really valued about the conferences over the years was the opportunity to meet colleagues from around the city, and know that you're not alone as an organizer. My work has been primarily on the Upper West Side of Manhattan and Harlem, working with SRO tenants, single room occupancy hotel and rooming house tenants, some of the most at-risk tenants in the city, and it's been my life's work as well as many other different types of campaigns. But that opportunity, we go around the room and introduce ourselves to one another and say something, and we've outgrown that. We don't have an opportunity to do that, but I like to do a little round ice-breaking exercise so you get a little sense of who else is in the room, and hopefully during lunch and other times, you'll have an opportunity to meet your colleagues and network somewhat. So I'm just going to ask for people to raise their hands if what I say applies to you. And first I'm just going to do a call out by borough so you can see who else is from the borough, from where you live or work, whatever you might prefer. So those folks, Manhattan, you raise your hands. Look around. Quiet from Manhattan. I know in Brooklyn, we say Brooklyn, we always get a shout. But first, we'll do the Bronx. I know Counsel is going to be quiet. The Brooklyn in the house. We always have a big group from Brooklyn. Queens. Hey, Queens. And Staten Island. All right.
I gotta be honorary member.
New Jersey. Come in from New Jersey. Not today, huh? Long Island and North. Rockland, Westchester?
Westchester, woo!
Okay. And how many people here are lawyers? Showing? How many people are community organizers? Woo! Elected officials, or work for an elected official? Welcome. Students, do you have any students today? No one, got a few, okay. It's graduation time, so we don't have many students this time of year. I work for a city agency, HPD buildings, anything like that. City agencies here today? Welcome, okay, we have representatives. How many people tenants? Tenants? Well, I'm your owner. Any landlords in the house? Okay. We serve these
Kids represent.
All right, a little more fun. How many fans, Yankee fans? Met fans? no baseball interest at all. I just engage your level of civic engagement. How many people are registered to vote? If you can. How many people have written a letter or an email or communicated with an elected official? Good active crowd here. How many people have been to a rally or demonstration? That business is picking up lately. How many people have been arrested doing civil disobedience? That would be picking up. I hope they give you some sense of the folks in the room. I like to always kind of close with a little call and response as an organizer. So we're going to do two, what do we want, when do we want it? We do what do we want, lawyers, where do we want them, housing court. What do we want?
Lawyers.
Where do we want them?
Housing court.
What do we want?
Lawyers.
Where do we want them?
Housing court.
What do we want?
Lawyers.
Where do we want them?
Housing court.
Okay, with justice. What do we want? Justice. When do we want it? Now. What do we want?
Justice.
When do we want it?
Now.
What do we want?
Justice.
When do we want it?
Now.
What?
Justice.
When?
Now.
What?
Justice.
When?
Now.
Thank you. So, you know the panel was supposed to start at 11. No, I'm wrong. I'm incorrected.
10:30.
Everyone, we're a little behind schedule, so we'll go right into the panel. Michael Williams is ready to serve as the board treasurer. He will serve as the moderator for this panel. Let's give Michael a warm welcome.
Good morning, good morning, good morning. And thank you for being here at the conference today and also for being present for our morning panel. I hope that we're going to have a lively discussion talking about both the present, what's going to be happening in the next month or so, and hopefully a bill will be passed in the City Council to bring right to counsel and housing court in New York City, but also just as importantly looking at the future and what right to counsel is going to mean for many issues of importance to us, for tenants previously unrepresented, for other housing issues like getting repairs done in housing court and the general efforts to organize for affordable housing in New York City. And we have a fantastic panel. To address these issues, we have Mr. Dressler at my far left. He is the coordinator of the New York City Human Resources Administration Office of Civil Justice, and he's going to be able to bring us the latest information about the proposals under discussion for the council to bring right to counsel to housing court. We have the Honorable Gene Schneider, supervising judge of the housing court in New York City, who will present us with perspectives from the bench about the expansion of counsel for low-income tenants. And to her right, we have Laura Russell, who is the co-citywide supervising attorney of the Family Law Domestic Violence Unit of the Legal Aid Society in New York City. She will be able to share her perspective on how right to counsel for certain litigants has worked in family court in New York City, and what lessons can be learned from that experience that can inform the gradual rollout of right to counsel in the housing court. And finally, we have Carmen Vega Rivera, who you've had the pleasure of hearing from earlier. She's a member of the leaders team of Community Action for Safe Apartments, or CASA, and is also on the steering committee of the Bronx Coalition for Community Vision. She has worked for right to counsels for years and will share perspectives on how things are now for unrepresented tenants in housing court, and also on what the right to counsel will mean as we move forward. So I will start, and we will start with Jordan Dressler.
Thank you, Michael. Thank you, Housing Answers, for having me. It's hard to call this a dialogue when there are so many voices that have been involved and have been heard. I think nearly all of them are in the room today. So, this is an achievement, and it's everyone's achievement. And so we all should be very proud that we're having this discussion about universal access to counsel, and that we're having it not about as an if, and not even really as a when, but as a how. And I think for all of us, it's critical that we get the how right We had a meeting recently in my office with folks from another major American city interested in what we're doing. The city which shall remain nameless, but the point is the world is watching, and so it is critical for us, as we know it's critical for you, that we get this right. And so on behalf of the City of New York, HRA, the Office of Civil Justice, we thank each and every one of you for helping us and working with us and being our partners in getting this right. So I think it's important to sort of take a few steps back to talk about how we got here. The past here is more than prologue. It's really sort of showing a path to how we move forward. So with the arrival of the administration, with the installation of the City Council in 2014, there really was this sense that it was time to really engage deeply with issues of access to justice. And so the first thing that happened was a reaction to the realization that there was work happening as far as what the city was funding, city council contracts and administration funded contracts, and they were, I think is a term of art, all over the place. And they were at this agency and that agency and this other agency, and they had different kinds of approaches to how they were being administered and really no central oversight. So the first thing that happened was that everything was brought under one roof, one umbrella at the Human Resources Administration. Leadership of Commissioner Stephen Banks has helped a great deal in that. And the next thing that happened was a realization that we just simply didn't have enough. So in addition to consolidating the contracts, particularly in the area of tenant legal services, the services have been expanded. I want you to consider that in 2013, city funding for tenant legal services was roughly $6 million. This current fiscal year, the one that we're wrapping up in a few short weeks, the funding for tenant legal services is $62 million. That's a tenfold increase. Part of what's happened through that increase is the exploration of different models, the exploration of different kinds of services. In addition to creating essentially, out of whole cloth, an anti-harassment and tenant protection program targeting select neighborhoods across the city that are particularly susceptible to pressures, unscrupulous landlords, and pressures of displacement, eviction. We worked on what a model for universal access to counsel would look like within the construct of a few select neighborhoods that we identified as being in particular need because of a very high rate of shelter entry coming out of those zip codes. We worked on zip codes, borrowing in great part from the HHP program and the work that has been already been happening in housing court through Access to Justice Initiatives driven by Judge Fisher. And in the last year to 2 years, we've been working hard on getting those models right. And there's a lot more work to do. But we were able to demonstrate that we can make something work. The other thing that happened in the course of this saga was the creation of my office, the Office of Civil Justice. Never before in the city of New York was there one permanent home for the oversight, the management, and the really creation of vision for civil legal services in the city of New York and low-income New Yorkers. The office was created by local law through the leadership of Speaker Mark Violino, council members Lavina Gibson, signed into law by Mayor de Blasio, and it was made part of the city charter. It is built into the fabric of the city. It is a permanent home. We were also empowered, in fact mandated, to really look at the issues by way of annual reports. The next one's coming out in a few months. The last one came out last summer, and we focused on what we considered to be the most pressing issue of the day. What is the story with representation in housing court for tenants facing eviction? There had been a fair amount of research over the previous decades, but it hadn't been updated in a long time. And without really rigorous research, looking with sober eyes at the issue in court, we thought it was impossible to have a meaningful conversation about how to create universal access to counsel. What would it look like? How would it be possible? So we did just that. And we saw that a few important things. Number one, where representation for tenants in housing court facing eviction was anywhere between 1% or 10%. As of last spring, it was 27%. More than 1 in 4 tenants in housing court had access to a lawyer. That was unprecedented. We've never seen that before. The other thing we saw was that we were starting to see very positive results. Over the 2-year period, residential evictions by marshals had dropped by 24%. These were results. This was impact. And so armed with that, armed with these findings, and with the leadership of folks like Counsel, the leadership of Counsel, essentially every single person in this room, we were able to move things forward. And so now we're about to embark on a 5-year implementation plan, building on what we're already doing. Right now, as I said, funding is at $62 million a year for tenant legal services. At the end of the 5 years, funding for housing court representation for tenants facing eviction will be $155 million a year, and we estimate that this will reach 400,000 New Yorkers a year. It's important, one thing's important. So far, we've been focusing most of our efforts on low-income New Yorkers. But in order to really change the dynamic in housing court, in order to really have a housing court representation model that works, that we can all look at ourselves in the mirror and say, this is fair. We thought it was important that every tenant, regardless of where they live, regardless of what their income level is, has access to counsel, access to legal assistance. So for those households who come before the court facing eviction, who are at 200% or more of federal poverty line, they will receive access to brief legal advice. For every household that's below 200% of the federal poverty line, they will have access to legal representation, full legal representation in court, a lawyer standing with them in court from the beginning of the case to the end of the case, and what may, regardless of merit, regardless of location. It's going to be difficult to get there. How do we know that? We're already encountering some challenges. I was struck by something Michael said. Think globally and act locally. I think that's what we're doing. It's certainly what we're trying to do. We're thinking globally about the goals that we have in mind to achieve when we have full access to counsel and housing. Making sure everybody has an easy way to make connections with the legal assistance. Making sure that the court operates in such a way that facilitates that connection between the lawyers who are available to help tenants and the tenants who need them. We're acting locally. We're dealing with the issues of access where the rubber meets the road in the courthouses themselves, and dealing with issues ranging from where people will sit and what the lines look like and what flyers might work. We're doing this with an eye towards modeling what will work, we'll reject what doesn't, and over time, and with your help, I think we can get to a place where we have a successful model for universal access to counsel and housing court. Fortunately, everybody's watching, so we have a lot to do to make it work.
I just wanted everyone to know there will be ample opportunity at the end of the panel today for you to ask any questions that you have of the panelists. I wanted to ask one quick question now, Mr. Dressler. As I understand it, the mayor has proposed an additional $15 million in funding, is that correct, for the next fiscal year?
Correct.
So in terms of those who worked in right to counsel for all these years, how will we be ensured that there will be adequate funding for the program from July 2018 going forward?
It's all built into the budget. I mean, we've already budgeted the dollars, so we're waiting for consideration.
And the money will be there?
The money will be there.
And in terms of quality representation, will there be mechanisms to ensure that right to counsel will mean also quality representation for previously unrepresented tenants in housing?
For sure. I mean, one of the things we're committed to doing is certainly continuing to partner with the variety of legal doing this work through the contracts they have with the city. That will continue, and through everything from regular monitoring and reporting to eventually we will get to a place where there will be a request for proposals and a new selection of providers, making sure that we have the right kinds of legal providers to do the work. We can both guarantee quality as well as access, as well as understanding of the larger issues at play is going to be critical for us.
Thank you. Next, we'll hear from the Honorable Gene Schneider.
First of all, let me say that for me, this issue is personal, and let me tell you why. An unbelievable 40 years ago, I graduated from law school, and as a 25-year-old new lawyer, newly employed at Bed-Stuy Legal Services, I went to Brooklyn Housing Court. That was the first court I ever set foot in. It was where the first client was that I ever represented in court. To give you some perspective, Brooklyn Housing Court at that time, and for some years thereafter, had a stamp made up, an ink stamp, that the clerk stamped on every application for an order to show cause. And the stamp was so that the judge could fill out, without writing the whole thing, how much money the tenant needed to deposit in court in order to get that order to show cause signed. The Housing Court had 4 judges at that time, where we now have 15. There were not fewer cases, in case anybody was wondering. And I can tell you that it was a very different place. Now, Housing Court has a very long way to go. The people in this room don't need to be like that, and believe me, I don't either. But in the 40 years since I first set foot in it, largely due, quite honestly, to the incredible leadership of Judge Vern Fisher, whom you heard from this morning, Housing Court has gotten more resources, better organized, real attention to what is necessary to open it up. After that period, I spent 20 years in civil legal services. I worked in Manhattan, in Brooklyn, and in Staten Island. I became a judge. I should say I took 3 years off to be the president of the Association of Legal Aid Attorneys and to do a little union work. I think there are maybe some members of that union here. I then became a judge 20 years after that, and as a judge I've sat in Manhattan and Bronx and Brooklyn. I apologize to those of you from Queens. Queens is the only housing court that I have not been involved in, either as an advocate or a judge. I'm trying to learn more about the Queens Housing Court as I go along. So for me now, coming back to the personal, I'm now probably about 5 years from retirement. And the idea that 5 years is going to be the 5 years in which we roll out universal access to counsel is just an absolute thrill for me. The idea that it's sort of a bookend for my career, and I couldn't possibly be more committed to getting it right in terms of how we do it and how it works. You obviously understand that we have some challenges ahead of us. The first year, as Jordan said, is going to involve an expansion of what we're already doing, and we hope that in this expansion, but moderate expansion, we will have an opportunity to try some things, different things in different places, in order to see what kinds of mechanisms for getting tenants connected to counsel, what kinds of mechanisms work better in different places. all of you can probably anticipate that our first and probably biggest challenge at this point has to do with physical space. In our two largest housing courts in Bronx and Brooklyn, our physical space is utterly inadequate for what we've got going on there already, and adding in the facility to connect tenants with lawyers and to get conversations between tenants and lawyers to happen in a sensible fashion is going to be very difficult. We do have a long-term plan for moving our Brooklyn court to new space, but every time I hear about that plan, it gets a little longer term than it was the last time I heard about it. I believe it will happen. I'm not really prepared to say when I believe it will happen, but I think that by early next year, we will have a new piece of space in the existing building that we can use as space for lawyers to meet with clients and do interviews. In the Bronx, we're hoping that on about that same schedule, we will have new space for Bronx. I think some of you have heard the buzzes about what the possible Bronx solutions are. It's not a new idea, but it's an idea which, because of the advocacy of many of you and because of this program, seems to be now on a front burner, and I'm kind of excited about that because it's long overdue. The idea that we have is that we can develop not specific offices for specific legal organizations, but kind of generic attorney space. So interview booths with some privacy where a lawyer from any legal organization can come in with a laptop or a other device and do an interview in private and then come out, and somebody from some other legal organization might use it next. We're trying to think about how to create that. One of the challenges that we have had so far is that when our litigants come to housing court, we've discovered that they are not that crazy about spending an extra 2 or 3 hours in order to be income screened and then be interviewed by a lawyer and then come back to the courtroom and see whether I get a lawyer or not, and then do this and then do this and then do this. We have some different ideas about how to streamline that process, but most of what has happened so far and most of the things that we're anticipating trying involve bringing the lawyers into the court so they're closer to where the litigant is anyway, and then finding a way to make it less burdensome for the person who needs to be in court but also needs to pick up a child from school and to do certain errands and to be at work and so on. That's going to be a big challenge, and we may try different kinds of things in different places. We will also need lots of input from you, especially those of you who are in court a lot of the time. Those of you who are interacting regularly with housing court litigants will have good ideas for us about what's going to work for people and what's not, what is working for people and what isn't. And we're going to be wanting to hear lots of feedback. Are there ways for us to get lawyers connected to litigants when they come to file answers? Are there ways for us to get information out to litigants before they answer to make connections? And how do we make sure that we're not missing anybody? The piece that Jordan mentioned about the people who are over 200% of poverty is of special concern. 200% of poverty is not very much money in the city of New York. It's not very much money anywhere, but it's especially not very much here. And so there will be a varying percentage of our litigants in different boroughs, but there will be some significant number of litigants who are over that number, but not in a position to afford private counsel. What we're anticipating is that the legislation is going to provide that each one of those litigants will get an advice session with an attorney. I think we're going to need a lot of creative thinking from our legal services providers about how we go about doing that, and by organizing groups as well. I'm struggling with figuring out how to accommodate space for the people who are going to be representing litigants in court. I would really be tearing my hair out if I thought I needed interview space for every single litigant to have an advice session with an attorney in the courthouse. So I'm worried about that, and I think that's something on which we're going to need a lot of creative thinking. Another thing that we're going to be looking at is how to adapt our existing access to justice programs to our new reality. And maybe there are ways to adapt those programs which were developed to address a situation in which we had lots and lots of unrepresented litigants, to target those programs perhaps at people who are between 200% and 400% of poverty, for example. Are there ways for us to reorganize those things? That's something that we're going to be looking at. The last thing that I want to say is that this is going to be a huge cultural change for the court and for everybody involved in it. I'm already really excited that in Brooklyn, some of the increased number of legal services lawyers who are practicing there are raising in an active and very effective way issues about the culture of the hallway conversations in Brooklyn, and starting to get the community of people that work in that court thinking about how that culture needs to change. As somebody that's been a part of that culture for 40 years, I could not be more excited than I am about that. I do want to remind us, though, that expanded counsel isn't going to solve every housing problem in the city of New York. It is going to, I believe, make housing court a much fairer place. And because culture is so important, I think that even in a borough like Manhattan, where there may be lots and lots of people who are over income and you may not blanket everybody, the fact that there are many more represented litigants will have a profound effect on the court. It's not going to solve affordability, for example. Affordability is still going to be there, and housing court with lawyers is not going to resolve that, so there's plenty of work to do. It's not going to resolve the fact that many litigants in housing court have mental health issues. It's not going to resolve all kinds of other things, but it is going to resolve a central thing that all of you and I have been concerned about for many, many years, and I'm really excited about it, and I hope we keep talking as we move forward.
Thank you very much, Judge Schneider. One question. The hallway conversations that you mentioned, given the volume of cases in the housing court, it's a common phenomenon that cases are settled in the hallway, and a very small percentage of cases would actually go to trial. Is that something that you anticipate might change, as is an expanded right to counsel over the next 5-year period and beyond?
That's a very interesting question. When Michael mentioned it in an email last week, I asked somebody to get me some statistics to see whether the number of trials is going up now. I don't have those yet, so I don't know. I can tell you on the basis simply of personal observation that there have been some noticeable changes in how cases move when there are tenants lawyers involved. One of the things that we've noticed is that there's a shift in where the court appearances happen. There are a few more court appearances early in the case. There may be a couple of adjournments. There may be some motion practice. So between the beginning of the case and the resolution of the case, whether it's by stipulation or a judicial order, is a little bit longer. What's shorter? Everything after that. Many fewer orders to show cause, much less post-judgment practice because the issues get addressed in advance and there is more focus on bringing things together there. I think it will be interesting to see whether there are more trials. I wouldn't be surprised if there are. There certainly is more substantive motion practice, I can tell you that.
Thank you. Now we're going to hear from Laura Russell of Legal Aid Society to bring the right to counsel ideas and how they played out in family court and see what we can all take from that.
Good morning, everyone. First, you all need to pat yourselves on the back and congratulate yourselves because the right to counsel in housing court is an amazing achievement. Amazing. The family court has had a right to counsel for decades. When I started in the mid-90s in the Bronx and then in all 5 family courts in the city, it was ingrained in the culture already. It's been ingrained in the family court culture, and that brings challenges as well as some changes to the court system. So I'm going to start by explaining how it works in the family court, and then I'm going to end with some of the continued challenges that we have in the family court and the right to counsel. So the right to counsel is for most cases in the family court. It does not involve child support and spousal support. And if you talk to any of the support magistrates who handle those types of cases, they will tell you how difficult it is with 2 pro se litigants to try to settle those cases or work towards those cases. And they actually have more trials because there is no attorney representing the parties to explain the law, explain what they're entitled to, and explain what's going to happen. In the mid-2000s, I was involved, as many others were, in moving the right to counsel not just into family court, but into Supreme Court in a divorce context. So the right to counsel for custody, visitation, orders of protection was also granted in the divorce process. But again, the right to counsel did not attach to financial issues. So we have a lot of concerns about people going into their divorces unrepresented in the financial aspects. And if you're all looking at me wondering how you only litigate half the case, that was a big issue. And it's complicated, and it doesn't work very well. But unfortunately, we couldn't move the legislature to attach a right to counsel for all aspects of divorces. So, the way it plays out in family court are there are 2 types of groups who get funding for representing litigants in family court, and that representation also includes anything regarding child protective proceedings as well as PINS proceedings. And the representation extends to the parents as well, and the guardians, as well as the children. So there are institutional providers. They either are providers such as the Legal Aid Juvenile Rights Division, who represents all the children in child protective cases, or there are providers who represent specific groups like parents in Brooklyn in child protective proceedings. And there are grants that are given to them to represent all of that group of people. For the groups of people that don't have grants attached to them, they get assigned counsel or 18B. And it comes from county law 18B, which is why they're called 18Bs. It's a similar process that's set up in the criminal system. And these attorneys are, they are private attorneys who agree to take an 18B rate that's paid either through the state or the city, depending on who they're representing, and they are monitored by an attorney review panel. And I want to talk briefly about the attorney review panel, of which I sit on for the second department. So there's a panel set up in each department that monitors these private attorneys. They accept complaints from their clients, and the complaints are forwarded to the review panel, and we investigate those complaints. The panel sends out questionnaires to the judges annually and asks the judges for their feedback on the panel attorneys. And so that we continue to ensure that the representation by the private attorneys who accept this money is of the highest quality possible. And I think if you go any route that involves a private attorney system, you really need to consider who is going to be monitoring these attorneys and making sure that they are providing quality representation. So in the family court, the different parts have specialties. So there's a child protective part, a custody visitation order protection part. Each of the parts have intakes. During the intake day, there's an attorney who sits there to be assigned cases. And Your Honor, this is what you were talking about, is when you're assigned a case, you then need a space to meet with your client. So the judge will call you up to the bench, ask you to take representation. You take that representation, you step back for an adjournment or a second call, and during that time, you have to talk to your client, because there are going to be things that happen right there and then that you need to know what's going on with your client. So you need a separate space, whether it be an interview room or offices within the court system. You need a space to meet with your client so you can, first of all, be able to respond effectively when the case is called again. But second of all, you don't want to waste that client's time. They're in court, they want something to happen. They're just getting assigned an attorney, and then they're going to walk away with another court date. They're going to have to take time off from work. You really want it to be an effective court appearance, especially for them. So the goal is that you're able to talk to them at that point in time. Some of the other concerns that we've had that attached at the beginning is that in the family court, you file a petition, you go before a judge, and you possibly get ex parte relief. There's no right to counsel that attaches at that point in time. The judge will grant or not grant the ex parte relief based on the pro se litigant's application. And that relief could be an order of protection, it could be temporary custody. So it's only after the client comes back and the other side shows up that the right to counsel attaches. And that was created as a system because there were not enough attorneys to represent the clients. So it's not a system that was created through the legislation. It's because of unfortunately, there were not enough assigned counsel and institutional providers to represent clients. So they determined that clients who had undefended cases did not need attorneys. If both parties show up in family court, there is a questioning by the judge as to whether the client wants an attorney. This is also something that needs to be monitored. A judge needs to tell them that they have a right to counsel, and if they cannot afford a right to counsel, that the court can appoint or that there are other legal services available there. If the court doesn't tell them that, many times people walk away thinking they have to pay for an attorney and they just can't afford it. So it's very important that judges are trained in knowing how to ask the questions about whether they want an attorney or not. Another issue that's a constant concern in family court is screening. Who is eligible for these services? And I can tell you the family court pendulum has swung from one end to the other. When I started, again, mid-90s, The screening question consisted of, can you afford an attorney? No? Okay, one will be appointed. It then got very into detail. You had to fill out a financial disclosure affidavit. You had to prove you couldn't get money from someplace else. You had to prove you couldn't get money from your pension, retirement, anything to get a lawyer, which was ridiculous. Now it's settling back into a system where the judge will ask them questions about their income and will determine from that whether they're entitled to an attorney. But so a judge questioning the client has drawbacks. Obviously, they're getting information from the client without an attorney present, without the client being told about what is the proper thing to say, what's the right thing to say, how to say it. But more importantly, it's taking the judge time to do this screening, to do this evaluation. And if they're writing anything down on paper, that paper is becoming part of the file. And so if they write down that they have bank accounts, and in housing court they get an arrears judgment against them, the landlord now knows all their information, which is not something that I would recommend. So something to really think about and be concerned with is, how is the screening going to occur? And exactly what are we talking about with poverty, with the 200% of the poverty guidelines? Are we looking at just income? Are we looking at bank accounts? How deep are we going to go? And I recommend not going very deep. I'm of the opinion that everyone deserves an attorney and that 200% is not enough and that it should be way higher. So I would say don't go very deep, but I will tell you that screening has always been a big concern in the family court, and we actually meet regularly with the family court judges to have conversations about screening, because some of the screenings that they're doing we feel are inappropriate. The other thing I want to talk about is that just because you have this right to counsel, this is not the end of the fight. It took us 30 years to get a right to counsel for the same type of case in Supreme Court that we had in family court. And we still don't have a right to counsel in support cases. So this is just the beginning. The implementation that you're going to go through and how this is going to be played out is extremely important. And then making sure that everyone has a right to counsel. To move forward beyond the 200% is also extremely important. Obviously, some of the things to consider is you have to look at caseloads. If attorneys have too high a caseload, it's near impossible for them to properly litigate cases, and clients fall through the cracks. So whatever funding is out there, it needs to be accurate and commensurate with the caseloads you're going to have. As I mentioned, you need to look at the physical plan. I know the judge mentioned this. I know the housing courts are cramped. I know the family courts are cramped. I used to say that the only difference between housing court and family court was that family court had a right to counsel. Now we're equal. So you have to look at the other services that attorneys have to provide and look at that in the funding. You're going to need translators, you're going to need interpreters, investigators, caseworkers. Some of these clients are not going to be able to just survive with an attorney's assistance. So the funding needs to be all-encompassing. It really can't just be, here's your attorney, good luck with that. A lot of our clients need way more than just legal help. The other thing to consider, of course, as we mentioned, is that the right to counsel only goes up to 200%. So then we're talking about advice and forms and clients going in on their own. There are times in the family court, and the family court goes up to 200 to 250%, but that is not a clear-cut guideline, and that is something to think about. Because you may have a client who has mental health issues, who speaks a language that's very difficult to even get a translator or interpreter for in court, but maybe they make 260% of the poverty guideline or 210%. They're not going to be able to navigate the system by themselves. We're not going to have pro se forms for 200 languages that are spoken in Queens. So, I mean, these are things that really judges and who's crafting this need to really think about. There's going to be clients who may not fit the income guideline, but for other reasons need an attorney. And the family court gives that flexibility. We have no set straight line rule about income. It's created as a guideline, and then it's implemented by the judges, and the people that watch that implementation are the legal services providers, the advocates, and those of us who are in the family courts on a regular basis. So I just consider, when you look at right line rules, that there are a lot of clients who may be 10, 20% over that line, but still are never going to be able to navigate the system by themselves. So, the other thing, finally, I just want to briefly mention is conflicts. When you do award contracts, or when you do, the reason that we have the assigned counsel panel in family court is because we have conflicts sometimes. When we look at our system, there may be two tenants who have adverse positions, and you need two separate agencies to represent them. There may be times when the agency is representing the landlord, and it's a small landlord and some other issue. And so you need to look at that. So you should never just have one agency per borough, and I don't believe this is something that you're looking to do anyway, but something to consider is that occasionally you do have conflicts in housing court, and there has to be other agencies that are able to provide the services.
Thank you. One question that I'm interested in, I think will definitely be an issue in the housing court, is that for the unrepresented tenants, I would expect that most of them see a long-term interest in having a lawyer, but in the short term, when they're offered a lawyer, the concern is, I may need to be here, or I get the impression I need to be here an additional hour, 2 hours, if I say I choose to have a lawyer. Is that an issue that's come up in family court? Have there been any changes in procedures to address that concern?
So it has come up in family court. People think that they can get in and out and be done in one adjournment. And family court, unlike housing court, has extremely long delays. At the height of the problems in family court, our cases were going on for 4 and 5 years. So one of the ways to address that is the judge to really explain that this is a complicated procedure and it would be better to have an attorney. And because when a tenant goes before a judge, they're going, even if they're so angry at the system, they're still going to listen to the judge and hear what the judge has to say a little bit. And if what they hear is, I need a lawyer, that's one of the best things. The other thing is, in the family court, you can say, I don't want a lawyer, and then a third of the way through the case realize you do, and say, Your Honor, can I have that attorney? So you can't say you're only entitled to an attorney at the first appearance. You have to look, and if the tenant says, you know what, I really need that attorney, then they should be able to get that attorney beyond the first appearance.
Thank you. Our final panelist is Carmen Vega-Rivera, who will discuss her experiences as a tenant leader with CASA and playing a key role in getting right to counsel happen in New York City, and also will have some lessons for us for the future of right to counsel.
So if you know me, you know I have to bring a little humor, so I'm not going to take it personal that I'm last since my name is Vega, and I've always been the last one in class. But I know I'm going to try to make this as brief as possible, because I know I'm between you, lunch, your break, and your cell phones. So if you have to stretch your arms and not away, I would appreciate it. Because I'm going to tell you my story, because my story has not ended. I said this morning that something happened to me. In 2008, my life was turned upside down. The life that I was accustomed to, being the executive director and running a philanthropic program at a teacher's college. In 2007, I experienced some health issues and an accident that warranted me to leave the life that I was used to, working with youth and their families, my passion. That was a hard transition. In the course of making that decision in 2008, I have been experiencing lots of harassment by my landlord since I had moved from the Lower East Side to the Bronx in 1981, having worked for the Bronx Museum of the Arts. When that landlord took over the building in 1987, By 1993, I had to form a tenants association. I gave it my all while running a nonprofit, but it wasn't always easy. As we all know, when you're running a tenants association, you have peaks and valleys. You have people who are interested, people who leave, people who give up, and then my own time is limited. But by 2008, the same issues that I was confronting by 1987, 1993 were paramount and they were escalating. I was still not getting heat and hot water. I had now become what they call someone with a disability disabled. I didn't have an elevator for weeks, months, half a year at a time. And now the basic services, not only heat hot water, I can't get to my laundry room, bricks and mortars were beginning to crack, water seeping through the bricks. And by the way, I live in an important pivotal building in the Bronx on 161st Street in the Grand Concourse, surrounded by all the courts, surrounded by law enforcement and attorneys and judges, elected officials, yet no one was doing anything about it as much as I tried to reach out. Things became so bleak in 2008 that since I now had the time and I was freezing and my health was deteriorating, that I decided to take on a campaign by myself. I was not involved with Counsel at this time. So I wrote a letter, again, handwritten because I couldn't function on the computer, to my landlord, demanding my rights, demanding services, knowing what they were from the little bit of work I was doing since 1993. That fell to deaf ears. It was basically unresponsive. When I was bedridden, couldn't get up, I got a lease that had not gone a lease from 2003 up until 2008, so I was a month-to-month tenant. Nothing was ever done, regardless of the system, regardless of the agency, regardless of the billions of dollars we spent on protecting tenants, but nothing. The outcome was bleak. So I took upon it to go on this mission of fighting this unscrupulous, horrible landlord and his son. That fight was wearing me out, but I wasn't going to give up. As Susanna and Shayla and everybody at Counsel knows, I'm that little yellow dove, but today I'm wearing orange, so I'm the orange dove in an amusement park. You can shoot me down, but I'm going to get right back up and fight with all my might. When I noticed that the lease was wrong, the amount was wrong, I started to put all kinds of applications with the HCA. My landlord, in the course between 2008 and 2009, decided that he would continue to do what he was doing, not deposit my rent checks, claiming I never sent them, even though I was prepaying them, not knowing what was going to happen to me and my family, and so forth and so on. You all know what the harassment tactics are. I was experiencing them all. I don't have to tell you one by one. No heat, hot water, just horrible. No repairs in my apartment, so forth. Finally, in 2000, at the end of 2009, I get a letter, notice, a petition saying he's taking me to court for non-payment. I was stunned. January, I show up to housing court thinking, well, this is going to be easy. I'm going to tell my truth. There's only one truth. He's got it wrong. He must, be the one with the error. I thought I was going to do the in and out through the revolving door. Well, that wasn't the case. I'm still in housing court. I have been in housing court since January of 2010 for non-payment. I had to consult my personal injury attorney, who is not a housing court. What the hell do I do? And he wasn't there for me because that was in his area of expertise. So I went in as a pro se and said, come on, Carmen, you could do this. You got the smarts. You're educated. You can speak. Well, it wasn't to a particular judge, Judge Lair, who I thank him, who supports the right to counsel, said to me, young lady, you're going to have to get yourself a lawyer, because they're taking you to trial. I have won an HP case by myself. Nothing happened. I have won a trial in 2014 with a judge coming to my apartment twice. Nothing happened. I'll tell you when things started to happen. When I walked through the doors of Counsel in October of 2011, I knew that something was going to happen, and it happened. By being involved with a tenant organizing organization such as CASA, knowing that I was going to have someone have my back, that I was going to learn more about my rights, that I wasn't doing this work alone, that something would happen. And immediately in that first few months, by January of 2012, we were now having the conversation about, damn, that Bronx Housing Court is nothing but an eviction mill and something's got to change. And I kept complaining to Susanna and Shayla and others. I didn't know that when I went to housing court that I wouldn't have an attorney. What's that? That there'd be 30, 40 people in front of me for legal services on the 5th floor, and that you had to be online outside, whether it was sweltering in the heat or freezing in the cold, to be one of those 5 or 6 people that would get a slot. And it all had to do with money. I'm disabled, but I agree with Judge Schneider. I'm slightly above that 200%. So who am I? Am I worthless? Or am I somebody that's worthy? Couldn't get any answer, couldn't get any support until I went through the doors of Counsel. Fast forward, in 2012, the tenants voted that we wanted to change the way housing court operated. And so we created the report Tipping the Scale, based on our concerns, based on my voice and many voices of what we were experiencing. I was stunned to see that agreements and stipulations are in the hallway. I was stunned to see that landlord attorneys have space dedicated to tenants and their attorneys as an office. I thought there was a difference and that they were not court employees, but they would have privileges and we had none. I had none. But I wasn't going to stand by and let that roll, as we say. I was going to take on this fight with CASA, with others, to say, what you're doing is unfair. If you are there to defend and protect tenants, then why aren't you doing it? Out of the growth of the Tipping the Scale report came the right to counsel. One of the biggest challenges for us was that we did not have representation. If it wasn't for Judge Blair who said, you're going to trial, get yourself an attorney, I had nowhere to turn to except to CASA. Because of my involvement in CASA, I was basically assigned an attorney, Urban Justice Center. If I had not been assigned the Urban Justice Center, I would have never won my trial in 2014. A trial that took almost a year to get a report in the January, the year later, to say he got an abatement, yet my apartment up until today is still packed and stacked as though I'm moving because they, the landlord and his team, refused to make the repairs. So winning doesn't always mean that you get what you want, but at least I had an attorney that can defend me, that can speak, because I was told many times in front of various judges to be quiet and not to say anything when I was fighting for myself. That's the kind of treatment that the tenants were getting. Our voices weren't being heard. And in my head, I'm going, if my voice is not being heard, then damn, why am I doing this work? Why am I here? I thought that housing court was to defend tenants. But in fact, what I started to realize is, no, it's the landlords that have the rights. It's the landlords that have the power. And I was determined, along with others, to flip that and to change it and not to take it. So now, not only am I involved with CASA, I have Urban Justice. We are now presently working with legal services because our wonderful building, 888 Grand Concourse, has gone through foreclosure, tax lien programs, just about an auction on February 6th, when one predatory equity lender sold the building to another predatory equity lender who loaned almost $18 million to my landlord. So if I can scratch my head, I would, but I have my hat on. And I'm dumbfounded of what happens in court and what continues to happen through that revolving door. As we know, in the Bronx, we have the highest eviction rate. The highest. But I was going to make sure that I wasn't one of those statistics. I'm going to make sure that my friend Randy is not a statistic, and all the other friends that I have grown to love and to be empowered with. So the right to counsel to me is basic. It's a fundamental principle. It's about humanity. It's about morality. It's about understanding our community. It's about saying, hey, she matters, he matters, they matter. We all have to fight this fight together. Without the right to counsel, as I said earlier today, based on my health condition, I was facing eviction. The fear of having to go into a shelter was paramount. If you have never experienced fear and you have no idea what it's like that you are one step from being inside a shelter with your family, regardless of how many damn masters you have, then think about it. Because this wasn't about my education. This was about the landlord who wanted me out to raise the rent to give it to someone else because I was organizing the tenants, because I was enforcing my right, because I was making demands, because I was asking for basic services, heat and hot water. How dare any landlord, regardless, good, bad, or indifferent, decide who's worthy, who's not, and who gets something and who doesn't. So I was counting on the court system that at times failed me, at times did not hear my voice, many times told to shut up. So the right to counsel gives us that voice, gives us that power, gives us that opportunity to keep a roof over our head. Housing is a human right. And no one, not a judge, not a court, not a lawyer, not a landlord should decide who has a roof and who doesn't. Thank you.
Thank you very much. What do you see going forward in terms of how tenant groups, which have worked so hard, tenant advocacy groups, including CASA, to get right to counsel happen in the housing court system in order to maintain that momentum going forward and continue being a source of pressure on the court system? And in particular, what do you think the goals will be for those groups in addition to and beyond the right to counsel as the rollout happens?
I think we said it. This is just the beginning. What the role should be. We're not going to stop organizing. We're not going to say, this is it. You know, woo-hoo that the mayor and city council speaker decided on February 12th to support this initiative. We have a lot of work in front of us. We need to allow tenants to understand, and we need the attorneys to help educate tenants that they have the right to an attorney regardless. That just because, you know, they have conditions in their building, they can get an attorney. No one, you know, I was feeling when I did say to you that I decided that I was going to check out my landlord and put my money in escrow. So I had a non-payment case that I won, but I also was trying to say I wasn't paying my rent. But I had no idea that I could sue my landlord whatsoever. It, you know, again, I have to give credit to this judge, Judge Blair, who, you know, said, do you realize that you can go next door in 560 and sue your landlord? I was doing this by myself. So there's so much work that needs to be done. There's so much in terms of education of our community. We don't want anybody to say, to your point, Laura, that someone doesn't want an attorney. I want to be the one to decide whether I want an attorney or not. I don't want any system or any government agency or any you know, entity that provides legal services to say you don't need it. So there's work that we need to do. We have to look for funding to make sure that our work gets done. We have to phase in the 5-year plan. We want to make sure that we don't set the right to counsel to fail. We want to make sure that it's effective. We want to make sure that everyone that needs an attorney is getting it. We also want to make sure, I'm going to be very upfront with you. I have dealt with attorneys and I'm like, damn, I didn't go to law school, but I know much more than that attorney, and I don't mean to put anybody down. But we need to make sure we have the right attorneys, that they're listening to you, actively listening, that they're telling your story, that they understand that they're fighting for you. Because there were times in my trial that I had to tell my attorney, I adore you, but you gotta get New York City swagger and you gotta bring it up. I'm going to lose this case. You know, so you have to make sure that the attorneys, just because we're saying there's money for attorneys, doesn't mean that we're getting quality. And one of the things that we have to build into the system is evaluating attorneys. They have to fight the fight for the tenants. Otherwise, all we're doing is putting a Band-Aid, and some people are gonna win and a whole lot of people are going to lose. I'm not about losing, I'm a winner. I'm about winning. And so with that fight is Attorneys have to reflect the members of the community. I'd like to see more people of color if possible as attorneys. I'm sure they're there. And law schools have to do a better job doing that. I happen to have been fortunate, but even though they look like me, sound like me, and maybe have a lot of things at the end of their name, doesn't mean that they're always fight for you. So we have to be very careful. So the fight is still here. We need funding, we need education, we need to work with organizations such as CASA and the like. And so there's a whole lot of work right in front of us. It's not the end, it's just the beginning.
Thank you. I'm going to open it up for questions. I've been told that there may be 2 hand mics that can float. There's one. There's another one. So I guess if people can raise their hands if you'd like to answer a question, I'll call on people and then we'll take it from there. But thanks so much to the 4 fantastic panelists. And we'll continue.
Hi, for Laura and Jordan, what about the possibility of hiring non-attorneys to represent people? Is this a job that paralegals or other legal assistants can do? I went to housing court and the landlord's rep wasn't an attorney. I'm pretty sure he was a paralegal. Because you said something about, okay, we need to hire this whole panoply of other investigators and
They would. So what I was talking about is people working under attorneys in law firms, law offices, and legal services. Right? You can't represent anyone if you're not an attorney. It's actually a crime to pretend to be an attorney. Because lawyers write laws. So. But there is a place for paralegals and case managers, but I think they need to work with attorneys. I think that one of the things that legal services and legal aid brings to the table and other non-profit organizations is that not only have we been to housing court, we have a depth of experience. So even our newer attorneys are supervised by attorneys with a lot of knowledge and a depth of experiences that you really need to know the full panoply of options that are available. So as much as I agree that they should work with lawyers and there's a place for them, I personally don't think that non-lawyers should represent tenants because they just aren't as familiar with some of the legal options and the procedural issues that lawyers are.
So when I was in housing court, I was working with the landlord's rep, right? So
I don't think
you're working with an
attorney though.
You were working probably, whoever the landlord was, had an attorney, and that person was working under the attorney and at the direction of the attorney.
Okay. So why can't there be housing for people doing that job? You know what I mean?
Well, we do have paralegals who work with us, but they're not going to court because the attorneys are going to court. They have more of the knowledge and the experience base. I think effective representation means that you're talking about someone who has the legal experience and has gone to law school and is working under supervisors who have a depth of knowledge. So I don't, again, this is my personal belief, I don't believe that you should have an organization or anyone who's not an attorney and has no attorney working for them to be representing tenants.
Many of the law firms that represent landlords in housing court use paralegals to do some things. There are some of those firms that have paralegals talking to unrepresented tenants, even drafting stipulations. The stipulation is then shown to an attorney who is present in court. It's the attorney who signs off on the agreement, and if there's a need to make an appearance before the judge, it's an attorney that does that. Many of the legal services organizations that have contracts with HRA to provide representation in housing court also use paralegals for a lot of different things. In a pilot program that was run in Brooklyn when I was sitting there, Some of the organizations were using paralegals to do the initial intake screening of the client for representation. Others were using attorneys. Different organizations take different approaches, but paralegals definitely have a role.
I just wanted to add, we've done a lot of talking here about sort of the culture of the court, the power dynamic of the court. Part of our commitment is to even that playing field. Based on our findings last year, 99% of landlords had counsel. Not access to a law firm, not access to a paralegal, but a lawyer in court. You're not going to even up that dynamic if you've got one side fully represented by counsel and another side with a legal assistant, a paralegal, some information. In order to change the culture in the court amongst landlords, amongst the bench, and amongst tenants themselves, that this is not some sort of offensive act to take advantage of legal assistance. That it's part of the deal. That when you walk into housing court and you're facing an eviction case, just like when you walk into criminal court, if you're walking or being brought in, it's not somehow that you might say, oh, well, far be it for me to take advantage of the public defender or the legal services organization lawyer who's standing next to me. I don't want to offend anybody by doing that. That it just becomes part of the package, that you have access to good quality legal advice to steer you in the right direction, and at a certain income level to stand with you for the duration of the case. So we're very committed to that model.
I support that lawyers have tenants, lawyers have attorneys, landlords have attorneys, therefore tenants should have attorneys. All the other services are great, but I would not want to be in court under my conditions of an HCA trial and have a paralegal or anyone else doing any services. Not that that's not important. In my case, the social worker would have been handy to help me with all the other issues. I didn't get any of those services. So it's important to level that playing field that Justin just spoke about.
Jordan. Good morning, everyone. I'm just curious, what ideas does the panel have with regards to what procedures or general steps we can take to make sure that demand doesn't outpace the supply of attorneys that we can have, which is an issue that Laura pointed out with family court, where attorneys have multitudes of load cases on their desk.
So let me just start by saying that when family court had the crisis that there weren't enough attorneys, the assigned counsel panel rate was $45 an hour. So the reason that we didn't have enough attorneys is that lawyers couldn't pay their overhead at $45 an hour and still take home a salary. So when the panel rate was raised $75 an hour, we actually got attorneys to come back onto the panel. So one of the things you have to do is effectively create contracts that make it so that legal services and legal aid and other organizations can have staff who have an adequate number of cases and who can represent their clients effectively at the level that they're being paid. And that's one of the best ways to ensure that everyone who can get an attorney will get an attorney.
Another issue that's related to that is it has to do with the rollout process. There is an issue which is the city predicting the correct number of cases out there in terms of what the financing is to cover it? And that we're going to, I guess, discover over time. An issue that I think is big in the shorter term is at what speed can our legal services organizations expand to take in these additional assignments. As somebody who spent a long time in a couple of those legal services organizations, I know that dramatic expansion in a short period of time is a very, very challenging thing to do. We have to allow for new lawyers to be hired. We have to allow for new lawyers to be trained. We have to allow for there being enough supervisors to train and watch over the new lawyers as they learn. We don't want people to be just sort of thrown in there, and I don't think any of the organizations that the city is working with are that kind of organization anyway. But I think that's going to be a very challenging process. And I think it's going to be important for you in the advocacy community both to insist that this happen at an appropriate rate of speed, because there's a tremendous need out there, but also to understand that these organizations are going to need to do something very, very difficult. And I think I understand that shortly after Gideon created a right to counsel in criminal cases, there were tremendous dislocations in organizations like the Legal Aid Society, who all of a sudden became just huge from nothing. And the young lawyers, I met some of the people who were new lawyers in that era on the criminal side, and who described some of the cultural changes that were really, really difficult. And I hope we'll be able to learn from that in terms of how we adapt to this.
I just want to underscore, funding is critical. Without the funding, we won't have the success. We have 5 years to roll this out. Dollars speak. We need to make sure this is effective. And I know through the community organizing side, we're definitely going to be pushing funding not only for more representation, training of attorneys, but also education of tenants. So funding, funding, funding. If we say it's not there, then we're setting up the right to counsel to fail, and we're not going to allow it to fail or fall.
With the advent of counsel for tenants, one would hope there'll be more motions, more written answers, more trials, more motions to dismiss, summary judgment motions, so that tenants get real legal representation. Is anything being done to make sure there are more judges available to make decisions on these kinds of what may be relatively complicated matters? Or are we going to stay with the same number of judges who are going to be totally overburdened and unable to keep up with what I certainly hope will be a deluge of paperwork?
I guess that one's mine. Right now, it's sort of interesting. If you could be a fly on the wall in discussions among judges, you would hear the following dispute. Judge A says, "Oh my heavens, this is going to be so much more work for us." And Judge B says, "It's not going to be more work, it's just going to be different work." Because right now, most of the work that our judges are doing is interacting with cases in which there are unrepresented litigants, and our judges are instructed by us. And I'm going to talk in a perfect world now. You all know that I understand that the world is not perfect, but in a perfect world, the judges are interacting with unrepresented litigants. They are explaining things. They are reviewing stipulations. They are explaining how to get an order to show cause. They're spending a great deal of time doing those things. If all of those people have lawyers, the lawyers don't need, I hope, to have those things explained to them. And so the judges are then theoretically freed up to do the things that judges in other courts spend most of their time doing, which is listening to argued motions and reviewing papers and making decisions on things that involve legal arguments. Now, you can tell from the presentation I just made which side of that discussion among judges I have signed up for so far. That is not to say that we're going to discover that I'm right and the other folks are wrong. We are going to be watching this very carefully. We're going to be watching our calendars. We're going to be watching our resources. We're going to be watching what our judges are doing and how we're dealing with things. And we will respond if it turns out that we need to. We certainly will.
I just want to add, when the rollout to rights and counsel went into Supreme Court, and when we were advocating for that, we asked the matrimonial bench specifically, with this Halper Hurt, because we wanted their assistance, and they were all so grateful to have lawyers on the other side. It is so difficult to try to explain the law from the bench when you're supposed to be fair and impartial, and then you have to explain what's going on, and that there might be a case for you, but I can't really talk to you about it because I'm the judge and I'm not the attorney. So I will also say that having attorneys on the other side makes the cases move faster, and it's less court time, and so whatever additional motion practice should be, and there will be some, and hopefully it will also, it will raise the landlord's bar. One could hope that if they know they're going to have attorneys on the other side, they're going to prepare proper petitions, for better or worse. So there will be an uptick in paper practice, as we call it, but in the end it will all settle out, and I think the judges are going to be very happy to have attorneys on the other side. At least that's the way it played out in Supreme Court.
Hi, over there.
This question is for Mr. Dressler, since you're the money guy. I practice in Staten Island Housing Court, and it is a very small courthouse. And I believe Ms. Russell and Ms. Vega talked about people meeting in the hallway and conferencing cases, having discussions. With the right to counsel, obviously that is going to be problematic, specifically in Staten Island, because we have no space at all, right? And so I guess my question, I mean, it's a very logistical question, but, are the funds, are you thinking about the funding for, additional space for stuff like that? Because that is a legitimate issue that is going to come up every single day, especially if we now need to, because I was unaware that we were going to have to give brief advice to people 200% plus. This is a major issue.
So we don't fund the courthouses. Courthouses are operated by the state. The state operates the courthouses. We're funding the legal services. I think we have to not let the perfect be the enemy of the good. You have fought for this moment for a long time. And here we are. And the courts are the courts. The physical plant is the physical plant. I think that we all share goals, and we have to get as close to those goals as we can, while also laying the groundwork for what should be. I think that there's a tremendous amount of planning going on even today about the future of the courts. The court system knows that this is coming. I don't want to speak for Judge Schneider, but Judge Schneider knows this is coming. There's going to be an enormous influx of lawyers and legal services coming to the courts. And the system will have to accommodate that. And there are certain expectations. In the most immediate term, we're going to have to operate within the confines of what currently exists and make sure that that works. So that's the point.
If I could just say that we have been out to the Staten Island Courthouse. We believe that there are some pockets of space that we can set up to be appropriate places to interview clients. They are not nice, they are not pretty, they are not perfect. But we think we're going to be able in the short term to adapt some space in that building to the purposes that we need.
Well, the only thing, just as a follow-up, assuming that you're speaking about something on the second floor, then you have issues with accommodating people that can't, because there's no elevator, there's I just had a baby. I know 5 months ago, I couldn't have gone up and down the stairs a bunch of times. So, I don't know. This is just logistical things. Obviously, we can figure it out, but I do think that is something that needs to be kept in mind if you really, in fact, do want to open a service.
Believe me, space is very much on our minds.
Second.
Hi, I'm a private tenant lawyer, so I have the luxury of seeing my clients not in court, but they come to my office, I close my door, we have a private consultation. Is there any thought to how to get tenants to see lawyers, not when they get to court, but before they get to court? And because I think then they wouldn't feel like they're being shuttled around like cattle. They wouldn't feel like just another part of the system. There would be much more dignity in the process of having a lawyer. So perhaps, as soon as a landlord buys an index number, the clerk sends out a notice to the tenant. You may have a right to counsel. Here's a list of legal services providers that serve your zip code. You should go talk to a lawyer before you come to court.
So, great minds thinking alike. It is precisely what we at HRA's Office of Civil Justice started doing last week for certain zip codes in Manhattan, with the express goal not simply to connect those tenants who right now, with our current programming, are essentially eligible for universal access to counsel today in Part G of Housing Court. I'll walk through the process in a moment, but also to see how effective would this be at scale in connecting tenants before they even set foot in the courthouse. So through a very productive partnership with the Office of Court Administration, we are fortunate to receive access to Housing Court data. And we received permission to send mailers to tenants within days of their receiving petitions, sort of plugged into the data, to send anonymous, right? It's not targeted. We know you are facing a case, but it simply says, are you facing an eviction case in Housing Court? You may qualify for a free lawyer. And a lawyer may do this, this, and this. It took a while because we had to translate into 10 languages to make sure that each and every tenant, or at least as close as we can get to each and every tenant who receives one, will be able to understand it and interpret it and take advantage of the connection with HRA's Office of Civil Justice to then, in turn, be connected with one of our legal service providers according to a rotation that we maintain. It's a minimal burden on us, at least at this scale, to at least try it. So far, the connections that we've tried along those lines, whether it's that sort of thing or connections at the answer window to then speak with us and then go over to a legal provider before the next court date, they have not been so successful. And part of it is just the rush of folks' lives, particularly the rush of folks' lives who might be in crisis at that moment. And perhaps just not really the issue of taking advantage of counsel being front of mind at that moment. That moment seems to hit, the enormity of the challenge seems to hit when folks are in court. So I think we would be foolish to plan how everybody would just get a mailer right after getting a petition, and everybody would call legal service provider X, Y, or Z, and everybody would walk into court with what is essentially looked like a model of private representation walking into court on that first appearance. We can't plan for that. We can lay the groundwork to try to accommodate that as best as we can. And it's more efficient if it works, because every case that gets connected before that first court appearance is one fewer case that has to be connected at that first court appearance. That being said, we're going to use a belt and suspenders and probably every other thing approach within this coming year to really model and see what's going to work and what's not. We'll pursue what works and we'll leave behind what doesn't.
I think ultimately it may be that we don't settle on just one way of connecting lawyers and clients. As for me, if some people can be connected with lawyers through that initial mailer, And if that turns out to be reasonably productive, maybe, although Judge Fisher would crawl under the table if she heard me say it, maybe we go back to that notice of petition and we add something to the notice of petition about how to get counsel. Maybe and that gets some people, and then maybe in some boroughs, if the place where tenants answer is set up in a way that we can make contact, maybe we reach some people when they come to answer. I think that so far what's been most successful is consistent with what we heard about from the family side, which is the judge being there saying, you know, there are complicated issues in your case, you really ought to think about having a lawyer. And then there will still be some cases, I can tell you from personal experience, where a litigant says, no, thank you very much, Judge, I don't need it. And then on the third order to show cause, I say to the litigant, how's that lawyer looking to you now? And yeah, I'd like to talk to a lawyer now. So I think there will be connection points all along in the process, and I think we'd be foolish not to try to use all of them.
I just want to echo what Judge Schneider said, because one thing that we've experienced just in the last couple of years is that as much as we can do for these other kind of access points to programming, there really is no substitute for the court to sort of imbue this with almost the majesty of the road and to validate the choice for the tenant to say, yes, I will take advantage of that lawyer. To say, look, this is an uneven playing field. You have this access. It's not, you have the power. You can take advantage of this. Where we've been most successful is where the court has played an active role in making that connection and making constant announcements to the courtroom saying there are legal services available and folks, and you can see them right here, and I'm pointing to you, pointing them out to you. We'll approach you to see if you are eligible. You may take advantage of this option. Where it's that judicial connection, at least based on our current experience, has been critical. So I think it's something that we necessarily have to pursue while also laying the groundwork for these other connection points to the extent that they're up.
I just wanted to ask, what plans are in place while all this eviction defense is incredibly important, but to also ensure that affirmative litigation to help tenants like Carmen go after the bad apples with group HP actions, or to have buildings declared rent stabilized to the American Community's goal of saving 200,000 apartments?
I just want to take a crack at that. I actually have 2 affirmative cases going on right now, HP and 7A trial that we begin on the 31st of this month. That's not going to change. There's funding for that. That's happening. Where I see and where the tenants are seeing the increase is on eviction. So we really need to make sure that there's funding, that there are reputable attorneys who are going to fight the increasing eviction rate. As I said earlier, the Bronx has the highest eviction rate, where 50% of the folks end up in shelters or in other situations. So the affirmative case to me are operating. If we can help reduce with the right to counsel and see a reduction of evictions, then we can start really focusing on the affirmative cases. We know that 97% of the cases are brought to court by attorneys for non-payment. I didn't know that I had the right to sue and do an HP. So maybe we can flip it. But right now, affirmative cases to me is not a priority. Eviction is, because that's where I'm seeing my neighbors, my community, facing the most horrible situations in housing court.
I have a follow-up question for Carmen. Like you were saying,
where's the voice? Yes.
Over here. Organizing is always going to be an essential, and now that we're seeing, in the first year, we'd be rolling out into, or increasing rollout into specific zip codes. Do you see our Counsel and other organizations planning on getting out in the streets, making sure that people are aware of what's available to them?
Well, most definitely. Yeah, that's what we do in CASA. Is get the word out through our various workshops, meetings, hitting the ground, getting folks involved through our various tenants associations. without getting the information out to the community, and we're doing just the same injustice to the community. So as I said earlier, this is not the end, this is the beginning. CASA and other allies, we have a lot of work in front of us. Funding is a piece of it. Funding organization as CASA to be able to do the workshops and the training of tenants, to be able to increase the number of tenants associations we work with. And I think we're working now with 40 plus. We'd be working with so many. 40 is nothing in the Bronx. 40 is my neighborhood, right? And the Bronx is huge with all the rezoning and gentrification that's going on. So this is huge. So the work is there. We're doing everything from funding, trainings, education, getting the word out one-to-one, because people still don't believe this can happen to them. I didn't believe it could happen to me, and here I am.
Hi, my name is Milagros. I'm a housing advocate at the Brooklyn Center for the Independence of the Disabled. I just wanted to throw out there to have the linkage information to the lawyers should this happen. I mean, I'm holding my breath and I'm excited about it happening, but should it actually happen, have the linkage information at the independent living centers, Department of Aging, the Lexington School for the Deaf to cover the deaf population. Those are just some ideas where you can have that linkage information for the lawyers.
Yes, I'd just like to go back a couple of speakers to the speaker who spoke about HP actions. I work with neighborhood housing services in Jamaica. We're seeing a lot more rent-regulated tenants in our office. And I've been doing some research on some of the buildings. Some of the landlords there are Park Cash and Zara, for instance. I'm looking at some buildings that have 70 or more units and have no violations in the HPD record. We've been getting information from tenants. There's a lot of fear among the immigrant community there. And what people, I think, need to see with HP cases and 7As is the confidence of the law being enforced in their buildings, to see housing code violations ameliorated and the buildings improved so that they'll have the confidence to come forward, especially in this time when there's a lot of fear about ICE and other organizations like that in this era of Trump. Where people need to feel confident that they can exercise their rights in their buildings and step forward and actually improve their living conditions. Beyond the individual stuff absolutely important to prevent evictions so the landlords don't deregulate the whole city. But I'd just like to get support that comment then about HP actions and improving conditions of buildings so tenants would feel confident about exercising their rights and know what their rights are in the places where they live.
Again, you can raise your hands if you have a question. So I can see you from here. Oh, sorry.
I was going to say that the right to counsel isn't about court eviction. It's about changing our understanding of what we deserve as tenants. And as we all know, rents are way, way too high. So I'm raising it if you think your rent is quite low. And a lot of us basically struggle to pay, and when we get a little bit behind, what we tend to do is we start to think that we're going to lose our rights to live with dignity and respect. And I just want to also say that let's remember that the right to counsel gives us that right, the right not to let your landlord threaten you, and not for you to think that you're going to be behind on your rent because it's your fault. We didn't place ourselves there. This is not our fault. We didn't create this. This is the fault of the city, where housing isn't a right and the landlords have too much power. And we know that because we see that in court every single day. Most everyone's rent is too high. And so that's a political problem and not a personal problem. And that's how we see it at CASA. This is political, this is not a personal. We didn't put ourselves in this position. We've been placed in this position. Also, and I just to the gentleman on the issue of affirmative action, when I said priority, it's not that eviction is a priority, is that we're going to have attorneys, and by having attorneys, we'll be able actually to increase the affirmative cases more and more, because hopefully the other, and as I said, the evictions will be less. And let's just remember that we'll be able to organize in our buildings. People won't be afraid to call 311 because they think they're going to be retaliated against or something's going to happen to them. I've been there. I've been attacked. I've been harassed, I'm still being harassed, but that doesn't prevent me from calling 311, from organizing in the building. So by having an attorney, by being involved with the right to counsel, it's going to empower me and other tenants. This is about tenant power. We created the right to counsel, the tenant movement did. And I want you to understand that we created it based on our experience. So now that we know that we have a defense attorney, or working with legal services, urban justice, and others, we're going to stand. We're going to stand strong. We're going to do things that we thought we couldn't do before because we didn't think that we would have that voice or have someone to have our back. So we're changing the playing field. We're leveling it. But it takes partnership, real partnership, to make sure that we're dealing with the right leveling of the playing field. Because we don't want losers and winners. We want the tenants to be the winners.
This is more of a comment than a question, but since there are policymakers sitting at this table, I did want to bring it up. Just going back a couple of rounds, but someone said we shouldn't let the perfect be the enemy of the good, but I would also say we should not let the universal be the enemy of the adequate, and that adequate should be the floor, not the ceiling. My concern in all this is that, and I speak as a tenant attorney, my concern in all this is that there's some skepticism in my community about how the rollout of right to counsel is going to happen and whether this is simply going to be a rubber stamp so that we can say every tenant had an attorney, or whether this is going to be meaningful right to counsel that levels the playing field. The question that was raised about spaces in the courthouse, I think if we are in, I think that's just one example of an issue with the rollout. If what we have is substandard spaces, if what we have is, as Ms. Vega-Rivera pointed out, we have inexperienced attorneys, if our caseloads are too high to be manageable, that will be apparent to the tenants. And it will be apparent to everyone. And just having the presence of a lawyer there does not automatically equal a level playing field. As much as I think my job is important. But there are a host of other issues that go into a meaningful right to counsel and meaningful equality and access to justice. And I guess I would encourage the policymakers to consider those and to fully consider those and to consider what that looks like from our angle, from the tenant's angle, and to come to the courthouse and walk through with us and see what we deal with, and see what the spaces are like, see what the treatment, come in wearing your jeans and your ratty t-shirt, not your business suit, and see how the tenants are actually treated, so that we can have so that this money isn't wasted and that we can have a meaningful right to counsel.
I think that the point is probably the best thing that's happening to assure quality is that we are working with existing legal organizations that have vast experience in housing court and that we know are tough advocates both for their clients and for their employees and their organizations. And we know that we can count on those organizations because they have a track record of effective advocacy. We are not creating a new outside untethered cadre of easy to manipulate lawyers. We are asking existing legal services organizations to hire, train, and supervise attorneys who are going to be in the mold of the ones they have already. I will absolutely grant you that interview space is a tremendous challenge, and it's going to go on being a tremendous challenge. And we are going to work like the dickens to get that, and one of the things I have to tell you is that people like Jordan and me are in the housing court all the time. And we're traveling around from borough to borough, and we're looking at what's going on, and believe me, we know it from the ground up. One of the things that has happened
in the last couple of months is that we have taken some of the higher up folks in the court system on a housing court tour and getting some of them to see some of what we see every day has been very useful in terms of raising the profile on our space issues.
Yeah, I think that's right. We are, like I said, we really are acting extremely locally in many instances. Looking by the floor, by the section of the floor to talk about what is the available space to facilitate the goals of meaningful access to housing markets. We've actually been pretty successful so far in in creating those spaces, in maintaining those spaces, where HRA is able to step out of the mix to allow for the providers to make use of existing space and play a more prominent role in that initial intake moment. We'll do that because we're committed to making it work. I think what Judge Schneider said is an understatement when it comes to the purity of the legal services providers in not just ensuring that there's access, but that the access is meaningful, that the conditions actually allow for zealous representation, and that is a process that will continue for the next 50 plus years as, the Gideon principle in this context becomes as commonplace as the Gideon principle is criminal court. If you don't think that they're fighting about conditions in criminal court, if you don't think that they're fighting about conditions in family court, notwithstanding the fact that those rights have been in place for decades, you're sorely mistaken. And the reason those fights are continuing is because the providers are committed to providing the best quality representation that they can and ensuring that they meet more than minimum standards, more than adequate standards, but meet excellent standards. Now, like with every process, you don't always get what you want, but they certainly try. And we're committed to partnering with all of our providers and the court on making that happen.
I just want to add, because I've been involved in several redos of various family courts, and our biggest fight right now is the Staten Island Family Court, which is not ADA accessible. But I will say this, get involved. I mean, I have been on planning, I've been involved in planning meetings, I've been involved in space meetings, and laying out a courtroom, trying to make a courtroom work better for the elderly, work better for the disabled, actually fit the amount of attorneys that sit at the bench, that sit below the bench in family court was a big challenge. Getting interview rooms, carving out spaces, they're not the best spaces. The Brooklyn Family Court years ago, before it moved, room closets were being used for courtrooms. So they did the best they can. But get involved in that space discussion in your borough, in your area, because it's really important to have your voice at the table during those discussions when any courtroom is being redone or refitted, or even an entire new building is being built.
Laura just transitioned perfectly to my shameless pitch for the Right to Counsel Coalition. But I just wanted to say that for us as a coalition, rights and laws are only as powerful as our ability to uphold and enforce them, right? And that depends on us, the power that we build. So if Right to Counsel doesn't build the tenant movement, that's on us, the tenant movement. And so we can't expect, with all due respect to the policymakers, that to come from the courts or from policymakers. It has to come from us. It has to come from how we use Right to Counsel. So I just wanted to plug that the coalition meets really regularly at this moment. There are robust committees. They're working on implementation. There's an implementation committee that's looking at space, that's looking at all the different points of access in the courts. We have a very robust funding proposal to say to the administration, to city council, to funders, that we can't just fund lawyers, we have to fund trusted community-based organizing groups in the neighborhoods where Right to Counsel is going to be rolled out. Because Right to Counsel isn't just about you get eviction papers, it's about every tenant who gets threatened with eviction because they're going to call 311. And so every single person in those zip codes has a right to know about Right to Counsel. They have a right to use it to then bring affirmative cases because they are free from fear around eviction. And so we really have to see it as raising the floor in the tenant movement to create spaces for bigger, better, and bolder wins. And so it really depends on how we use this new right that we get it and what we turn it into. So what we definitely need folks' help. We're trying to get funding for organizers in every single zip code where Right to Counsel is rolled out. We want to put on community forums. We want tenants who go through the court to be able to participate in focus groups and surveys, give feedback on the implementation, on space, on everything. So I really hope that everybody in this room who has questions, who has concerns, who has smart ideas, who's skeptical or not, join us, because that is going to make this coalition stronger, it's going to make the right stronger, and it's going to make other wins like fighting vacancy decontrol or other things we need to fight for stronger, because this is a step to build a tenant movement.
You can wait for the mic, or depending how loud your voice is, you can start with that.
Yes, I thank you for such an interesting forum. But we shouldn't forget that in America, we're 5% of the population, the world's population, but yet we incarcerate 25%, and we incarcerate them in a system that provides them with legal counsel. So clearly, as many of the panelists pointed out, as members of the audience, having the right to counsel is not sufficient. I remember as Ms. Vega gave her presentation, she talked about a Judge Lair who took it on himself to make certain recommendations and suggestions. And I think in that capacity, maybe Judge Lair stepped out of his role of being middle and not taking a side, and leaving that up to the lawyers to argue on both sides. I think, I'm not sure where this should be placed, but maybe there should be something done to give the judge in a court proceeding some kind of duty to do justice, which is if he sees something that is terribly wrong, to say something. And as it is now, I'm not sure that the state constitution gives a judge that much leeway. I think he's just in the middle and he allows both sides to argue. But if somehow we amend, well, I'm not advocating pro or con in terms of a constitutional convention, but if the judge was given this power or this duty, and a duty is something which he must do, to if he sees injustice taking place, to say something. And I'd like to know what I think, I forgot which of you are the judges, but I'd be curious to hear your comment on that. To give the judge a duty to do justice. Thank you.
I thought we already had that duty. Seriously, I really did. I really do. I wouldn't be a judge if I didn't take that route.
Housing court judges never sanction a lawyer.
I think in the European Union, all right, the judges have a specific duty which is outlined. Maybe you view it as some kind of tradition as a duty, but I think it's clearly outlined. I think judges will feel more comfortable because I think Judge Lair, as Ms. Vega described, is not the typical judges. I mean, I've observed court proceedings in landlord-tenant especially, and it's not the general duty of the judge to advise a particular defendant a particular party who does understand the law, what he or she should do. That, as Ms. Vega described, is the exception and the rule. Thank you.
So, let me think how to say this. I actually think in housing court that every judge in the housing court sees himself or herself as having an obligation to do justice on every case every day. However, the 50 of us don't all agree about what justice is on any particular case on any given day. And one of the reasons why I think it's important to put a lawyer in there for every litigant on every case, if we can, is because whether the judge sees it that way or not, a lawyer has the opportunity to present the law in a particular way. The difference in some of the EU countries, at least, I think the judge has an obligation to develop the record in the way that some of our administrative judges do. Ironically, in housing court, through administrative directive, we have given housing judges a lot more obligation to do that than most judges in most American courts think is their obligation to do. Because we have recognized ourselves as being unusual in the sense of having had for our entire 40-year history most of one side represented by counsel and most of the other side not. And so we have given our judge, through administrative directive, we've given our judges an obligation to look further than just sitting there. Because if you just sit there and one side has a lawyer and the other side doesn't, you don't necessarily achieve justice. The idea of what we're trying to accomplish with universal access is a balancing that doesn't depend on a particular judge on a particular day seeing a case in a particular way. It is not, as I said long ago, it's not going to solve everything. It's absolutely not. But it's going to solve, I hope, a lot of the things that have been frustrating many of us for a very long time. It's not going to do everything. And we've had a right to counsel in criminal cases for a great many decades. And I don't think there is anybody in this room in any chair who would claim that the criminal justice system was operating in a fabulous way every day on every case.
I will second that. But I'll also say that there are some things in the criminal justice system that I think are good models, particularly the role of legal providers who wear, just by their very nature, two hats, both as individual advocates in individual cases, and then as issue spotters and thought leaders. I don't know if anybody's familiar with this thing of gravity. There's a provision of the administrative code that says that if you've got a particular kind of knife of a particular length, and it flips out by force of gravity, it's illegal. Meanwhile, they're selling them all over the state. And these cases have been prosecuted in the city's criminal court for many, many years. And legals, criminal defense attorneys, have handled those cases. And there was an inherent unfairness around that. And it sort of bubbled up from the bottom, bubbled up from the line attorneys, through supervisors, through motions, and then eventually to advocacy, where there was legislation in Albany. Honestly, can't tell you what the disposition of that legislation is, but even having the movement really came out of observations and actions taken at the ground level in the court. The linchpin there is having the lawyers on the ground to even see it. So I honestly believe that there are going to be phenomena in the courts, phenomena in the law, that we don't even know right now, that will be revealed through the application of legal services. That will be revealed because you've got creative lawyers essentially being forced to represent cases that under an old regime, it wasn't cherry picking to say, I'm not going to do this case, I'll do this case where I know I've got a defense in place. It was the smart use of very limited resources. We're committed to providing the resources so that everybody's going to have access to that legal assistance. And what's going to happen is a lot of your so-called no defense cases, well, they're going to have a defense because they're going to have a defense attorney. And sure enough, we're already seeing that there are cases, and they were reported in the Law Journal, and Josephson was here before, I email them these decisions every week when I see them in the Law Journal, where these very small picayune issues of notice, of how something was drafted, about how something went in court, lawyer stuff, that no pro se litigant could ever possibly be sensitive enough to raise, to even know. And sure enough, they're leading to positive outcomes for tenants, sometimes delayed outcomes. allowing for a softer landing, sometimes full-fledged victories in court. We're only going to see that with widespread access to counsel and housing courts.
Hi, I just wanted to know what kind of checks and balances will be put in place to make sure that the funding that becomes available to New Yorkers is distributed in a way that's not disproportionate per borough, because working in the Staten Island court with the few folks that are back here, as we are a tight community, we are also very aware of the limited amount of resources that we get on Staten Island. And so, as many lawyers prefer working in boroughs that are closer to them or that offer more resources, I'm curious as to how that will happen particularly in different boroughs particularly.
One of the things we're committed to is, as we incrementally roll out and grow year over year over year, to be doing that in every borough of the city, so that next year we'll be rolling out in zip codes in each borough in the city. Currently, our expanded legal services program is operating in 2 boroughs per borough. We're committed to doing that not just because of fairness, not just because we want to make sure it's covering everywhere, but also to begin to instill in each courthouse in the city a sense that where these programs are operating, they're universal. So there is no merit screening as we roll out these phases. We're only going to do these. There's no policy we're only going to do cases. There's no any holdover cases or anything like that. It's if we're covering this zip code, then everyone has access to counsel in this zip code. And again, selections of zip codes, we've actually been in a very good dialogue with advocates, some of who were in the room, about sort of how you choose, how you prioritize. And I think there's actually a very good conversation around that. And we've received some feedback that I thought was helpful to us in developing this in conjunction with other codes. But the premise that we are going to do this in every borough, that's been paramount as we go.
And just to follow up, and you may or may not have the answer, but in the interest of meaningful access to justice, who checks the lawyer's credentials?
As we have, it's a process that I think starts with the city's setting conditions for even doing the work. And one of the conditions is that we want to be working with providers who are a long history of doing this work, with quality representation, requirements to maintain training, to maintain supervision, and so then the providers themselves, the organizations themselves have responsibilities. And of course, the lawyers have responsibilities that are not only overseen by the court in the individual cases, but by the membership of the
I want to take that issue to Ms. Russell in terms of how the attorney review process has been working in family court in this respect, from your perspective.
So family court has 2 mechanisms. First is the assigned counsel panel, which are private attorneys, which I don't see this initiative going in that direction. But with regard to the institutional providers, we're talking about legal services agencies that have been doing this work for decades, or over 100 years sometimes. And they each, when they hire, and I'm one of them, when we hire, we look at experience, we look at credentials, we look to see how you've worked with the community, how you're going to be able to work with the community. And obviously we check that you're admitted to the bar, that's the first step, or about to be. So we do this intensive screening, checking references, and then we go through interview processes that have, for a staff attorney, 2 levels. And our supervisors all monitor their caseloads and go over their cases, go in the beginning, read all their papers. Our supervisors, at least in the Legal Aid Society, are all very experienced and qualified. I know in Staten Island, Teresa's been doing this for decades. And they look at every case and see every angle that's going on, at least in the beginning of the staff attorney's career with us. So, and I think every legal services provider has a similar process. So we're all making sure that everyone is getting quality representation, whether the staff attorney is brand new or has been doing this for 20 plus years, because you're in an office where you're going to be reviewed by someone who's been doing this work for a long period of time.
From the tenant perspective, we're going to be evaluating attorneys. As I said earlier, just because just because you have the credentials, just like teaching, right? Teachers have credentials. I sat on the teacher certification board, and I can tell you people came in for certification should not be teaching. Same thing with attorneys, because you have the credential doesn't always mean that you will make the right defense. And so through the work, through tenant organizing, through CASA, and through training of the community, education of the community, we're going to make sure that we're also evaluating in the same way that we looked at and observed what was going on in housing court and not going on. We'll be doing the same of delivery in terms of defense, and which attorneys we feel are making an impact, defending the tenants, and which are not.
Hi, this is Andrew. I'm up from the Bronx. I've been doing this work for about 27 years. And I just want to share some thoughts with you and maybe the next step. There's a problem of affordability. I would say 30% of the people who seek assistance in my office have already had a one-shot deal in less than a year. And I just see it just the cycle. So they got a one-shot deal, and in less than a year, they're already falling behind. Now, why? There's a problem there. The other thing is, the last data I saw, the like 868,000 rent-stabilized apartments in New York City, over 30% are preferential rents. Up where we are, Norwood, Bedford Park, Pelham Parkway, we are seeing the people from Brooklyn, Queens, and Manhattan coming up to our community and saying to the landlord, you only want $2,200 for a two-bedroom apartment? The size of those rooms, are you crazy? Where do I sign? They want these apartments. My clients are coming into my office crying. De Blasio said, oh, a one-year lease is 0%. Why did my rent go up $400, $300 a month? What happened here? Preferential rents. And I look at them and say, unless we can get a printout of your rent history from DHCR and somehow prove that there's, they can only go back 4 years, blah, 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 blah. And unless you can prove that that legal rent is incorrect, guess what? You're stuck. So, and they always wait, they get their lease renewal, sits on the kitchen table for a month, 2 months. Guess what? The lease is up by the end of the month. Meanwhile, what do? You file with the HCA, it takes them a year, year and a half, 2 years to come up with a conclusion. In the meantime, they tell me, what do? Do I pay my rent, my old rent? Do I pay the new rent? You pay your old rent, you end up in housing court and a holdover. So, to me, it's affordability, and we have to take it from the city level. We have a progressive mayor, progressive city council. We have funding. We have this great right to counsel. That's really great. We need to get on the state assembly and state senate and have preferential rents locked in. So all future rent increases are based on the preferential rent. Otherwise, that 30%, they're going to end up in housing court with a holdover. So I just wanted to hear if anybody has any reaction to that. Thank you.
I just want to, you're welcome to, we just did a white paper, and you are welcome to come this Thursday to CASA from actually 9:30 to 11. This is the topic of discussion, so you're welcome to come. So it's at 1501 Jerome Avenue in the Bronx, 572nd Street. Especially since you're in the Bronx, I would suggest that I'm extending an invitation to suggest that you join us on Thursday this week.
And then over there, to my right.
I have more so a uniform standard enforcement question. So when the right to counsel is rolled out, who is going to be ensuring that the tenants are actually going to get representation? Because I work in Staten Island, and then every day when I go to court, there are tenants who have the fortune to actually meet one of the attorneys from legal services or legal aid or any other legal service providers and tell us that they had never heard that they could get free counsel. If they had heard about it, they would have asked for help. And oftentimes we meet them after post-judgment when there's actually a settlement that's been entered into, which is egregious. So in order to ensure, like, once we have right to counsel passed, I mean, once that's the law, how are we ensuring that the tenants actually get counsel? Because if the tenants don't know about the attorneys in the room or the services that's being available to them, there is no way to help them. So how is that enforcement going to look like? And then who's going to have the burden to ensure that the tenants are actually represented? Is the court going to do something about it to ensure that the tenants are aware that the services are being available? Because one of the things that, I don't know about other courts, but in Staten Island we definitely do not have any announcements about free legal service out there for indigent tenants. Neither the court attorney, neither the court clerks, or during the calendar call, no announcement is being made, so oftentimes tenants do not know that there are attorneys who could help them.
The answer to the ultimate question is on the court. If a litigant who's before the court has a right to certain services before the case goes forward, it's up to the court to make sure that that's enforced. Period. There's, in terms of the rollout, we have some fits and starts. And you mentioned that you were in Staten Island now. There are certainly fits and starts in Staten Island, and we have commitments from the judges there to try to address the situation, and they're very enthusiastic about it. But as you heard from somebody else at your table, there are some fairly serious space issues to be addressed in Staten Island, and we are trying to get to the bottom of that and come up with some solutions.
I just want to add, when we're in family, first of all, when we're in family court and I'm sitting in the court and I see that the judge is not doing it, I call the supervising judge. And most of us have good relationships with a lot of the supervising judges and just say, hey, Judge so-and-so keeps forgetting to mention that there's a free attorney and it's a right to counsel. And that usually will remedy the problem. I also suggest this is where the tenant organizing committees and groups and paralegals can just sit in the back of the courtroom and listen to the judge and see if the judge tells the litigants that there is a right to counsel available once it's rolled out. And then issue a report. We've had those reports in family court for right to counsel, for how right to counsel is being taken, for how the screening has happened. And we've listed, we sat in the back, and even when the lawyers go and sit in the back, we're not looking like lawyers. We sit in the back in jeans so that nobody knows who we are, and hear how the judges ask about a right to counsel. And that's something that I think everyone in this room is going to have to do to monitor, to make sure that the right to counsel is that the judges ask the questions effectively and that they do ask the questions so that litigants do not feel uncomfortable saying, yes, I do need an attorney.
Take two more questions.
Yes.
One actually, he was waiting.
Thank you.
Hello, I'm Eli Kimmels. Judge Snyder especially, I was wondering how you anticipate the relationship to be between the right to counsel law and right to counsel program and the current housing court guardian and lighting program.
The two programs are very different because the role of counsel is very different from the role of a guardian ad litem. And the counsel program, the universal access program, will expand the range of people who are entitled to lawyers. But
the law says that just because you have a lawyer doesn't mean that you don't get a guardian if you're a person who needs a guardian. I would anticipate that there will be some interaction in the sense that a judge may send a litigant to talk to an attorney, and an attorney may feel that this person needs to have a guardian ad litem first because it doesn't appear that the person is in a position to retain counsel without having a guardian, so it may be that sometimes it goes that direction. It may also sometimes go the other direction, that there's counsel on the case, and the counsel then makes the motion for appointment of a guardian ad litem. It may make the guardian issues a little easier in some respect, in that sometimes a judge who doesn't have a lot of options in terms of getting counsel for somebody will appoint a guardian ad litem in circumstances that don't perfectly fit what the legal definition is of who gets a guardian ad litem. If counsel is more available, and in fact is universally available, we don't try to put square pegs in round holes quite so often.
I think that's right. I'll throw APS into the mix too. Yes. I think that there, over time, for very good reason, has been a desire on the part of the folks in the court, including the landlord side, to get somebody who is particularly vulnerable some help. And so the options have been fairly limited. The frustration can be, particularly around APS, where it's, well, let's just get this tenant APS and see what happens, because, you know, lawyer, landlord, tenant alone, I'm sorry, judge, landlord, tenant alone is not enough. And standards for APS are quite high, and they're dictated by the state. And so there can be a frustrating moment towards the end of the case where APS has been monitoring or reviewing, and then in the end has to reject the case, and then it's as if a net has been pulled out from under that tenant. So we're actually actively working on that particular situation now, and some of those cases are GALs and some of them don't. But the hope here is that with the introduction of access to counsel for all, the roles here can be maybe clarified, right? Just because you get a lawyer doesn't mean you do or you don't need a guardian. Just because you get a lawyer doesn't mean you do or you don't need APS. And just because you get APS doesn't mean you do or don't need a guardian, right? There are different functions. Some of these functions are clinical in nature. So hopefully with a more mature access to counsel program, which we don't have now, we have one in transition, these roles will be even more clarified, and that desire, that good desire on the part of a lot of folks sort of mixed in the system to get somebody some help can be answered first and foremost with counsel, and then the more important questions about vulnerability can be answered and responded to.
If I can just point out that a guardian ad litem has the authority, I understand, to talk directly with a petitioner. That can sometimes be an asset.
Thank you. I have, oh, go ahead. You need the mic or no?
No, I'm okay.
Last question.
This is a related question, but it doesn't have to directly do with housing court. I'm a parent advocate and family member service of Cardinal, and an issue.
You need a mic.
Let's get the mic.
You need a mic.
Oh, sorry, it's a big room. So an issue facing our clients that's really dire and has always been an issue is their lack of ability to find stable housing, not just to protect the housing that they have. And I was wondering if the panel had any suggestions or resources for us to potentially refer to clients to help them find housing in the first place. Did everyone hear that? Okay.
That's one of the things that this universal access is not going to address. Affordability, availability, those are huge problems. They're frustrating for everybody up here on the panel and have been for decades. And there's not a lot of
There are not a lot of resources out there. There are not a lot of organizations that do housing searches with people. There are a lot of social service agencies involved with people who are in housing court that specifically don't do that. Maybe because it's really, really hard. So I don't have a lot of help.
The housing court piece is going to go a long way in ensuring somebody has the right to remain in their home in many cases. The stability of that is a separate issue. I would recommend home base, particularly now as home base is being sort of reworked and revisioned. We can talk afterwards about specifics, but in terms of access to subsidies, access to financial assistance, and just sort of that host of surrounding services can be very helpful in maintaining the stability of housing so that it's not just there after the end of the case, but there for a long time.
I wanted to thank all the panelists for a very interesting presentation, and also to the audience members. And just very quickly, the one thought I had. Unfortunately, because it's almost 1 o'clock, and the executive director wants to make an announcement before we finish up.
Go ahead, Jim. Okay, I'll make my brief comment. I hope I'm helpful. Let us not forget that how you make money in New York City is by real estate. So the movements that must go on, the tenant movements, you look at the 13 low-income neighborhoods that are being gentrified because real estate still runs New York City. You don't know how grateful I am, because I was in Panama City, Florida in 1963 when the Gideon case was decided. But that didn't apply to black people in the South. I chaired the first meeting of the Bronx Task Force on the Housing Court in 1979 with Judge Nolan. But when we brought up right to counsel, he just laughed at us. So you see how long it takes to build and sustain movements. I was in Eleanor Butler's house the afternoon she was assassinated. And over a period of time, we were told, we will no longer evict senior citizens. Can you believe that? A few months later, they started evicting senior citizens. So my just main point is that we can't forget that the South Bronx lost tens of thousands of apartment buildings, hundreds of lives. We got mass incarceration. So it's just a general statement of justice. Real estate runs New York City. Do you understand the battle, the movement of tenants who must come together to face this? Thank you very much.
Thank you so much to the panel. Thanks for coming today. And thank you so much to the audience for asking really interesting questions. I think this is a story still evolving. I just wanted to talk a little bit about the afternoon. So first of all, there's lunches out when you go out these doors, out in the hall, they're in a box. The doors are open, so you can go out on the terrace if you want to. You can stay in here, and there's also the lounge area over there. You're welcome to go wherever you want, as long as you don't disturb the students, I think. The afternoon, we'll be giving a presentation in here at 1:30 on our new booklet for night shift tenants, and in the afternoon we're going to have 3 separate things that you can do. One is the continuing legal education that Andy will be giving on the history of the civil Gideon and the right to counsel in New York City, which will be in the Bateman room, which is if you go through these doors and see the lounge is over on the other side. Obviously, if you're an attorney, you have to sign in and sign out if you want to see all the credit. Those of you who don't want the credit, you don't have to do that. In this room, from 2 o'clock on, we're going to have some small workshops and some tables, and then in the center of the room, we're going to do a right to counsel teach-in. We sort of mismanaged the dividing of the room, so we're going to try to do both those things in one room, and the right to counsel teach-in will be for those of you who expressed all these really amazing opinions and questions today. And talking about like what it means, how this coalition works, and how to get involved in it. And once again, I just want to remind everyone that there's on May 22nd, there will be a right to counsel teach-in on the Lower East Side, and I think we'll be doing more of those around the city so that more and more people will be
So, the only other thing I wanted to say was, I don't know if it's still a problem, but the ladies' room was sort of messed up a little bit. There's only 2 stalls there, but there's more bathrooms down these stairs on the first floor and at the other end of this hall, I think, that way, or maybe downstairs by the elevators if you can't get in there. All right, so we'll see everyone back in here at either 1:30 or 2, depending on your afternoon desire. And thanks again to the panel. You did a great job.
Are people cleaning up? Like, do we, or do we clean this stuff up? I'm not sure. I mean, I think we should do it. No, I mean, like, there's like all these tables. Do we clean this stuff, or there are people coming back in here, or do we have staff doing coming back in? Okay. Whose camera?
I think
your camera, yeah?
I think I can double check if it's on. That's Jessica's camera, right? No, that one's.
That's mine.
Yeah, this is mine.
Mommy brains. It's okay. I'm sorry.
I don't know whose iPad this is.
That's the office's. I'll take it. Got it? Okay. And then the computer. Oh, crap. I need to stop live streaming. I know, right?